So provided the court with some tape recordings to listen to.
Yeah, there's one left that I was just provided this morning. I'm halfway through listening to it. I think it's going to be fine, but I just have to finish it.
I have listened to these particular tape recordings, and some of them were specifically the subject of prior hearings and rulings by the court. Others were not previously heard by the court, so I didn't specifically rule on them, but offers of proof were made as to them, as I recall, as to most of them, if not all. And as far as Exhibit 348, and 334, 329, 332, and 333, all tape recordings relating to Oziel and Smith. Did the defense wish to be heard further?
As to 329, that tape was played for the jury without objection, so the tape itself should be admitted into evidence. As to 332, we would again offer that tape. I know the court has previously rejected that, but the rejection was done before Ms. Smith testified that it was Oziel who was the one that had a habit of calling up and disguising his voice, and she gave that testimony in reference to the audio tape that was played in which he told her to call up his wife and disguise his voice, and she testified that he had several ethnic voices, she described.
I recall that, and I recall the court's ruling at the time, and the court's ruling will stand as to 332 is not to be received.
333 and 334 are offered to contradict Dr. Oziel's testimony that the only reason that he revealed the client confidences of the Menendez brothers was because of the supposed threat that was made on his life. And it's our theory of defense that, and testified to by Ms. Smith, that he routinely disclosed the confidences of his patients. And 333 and 334 are both tapes in which Dr. Oziel is telling Smith about therapy sessions he had with other patients. So these tapes are being offered not for their truth, but to show that Dr. Oziel was revealing confidences of other patients to contradict his testimony that the only situation in which he would reveal confidences would be if he received a threat such as he said he supposedly received from Lyle Menendez.
Under Section 352 of the Evidence Code, the court finds the probative value of that evidence is substantially outweighed by its potential prejudice and confusion of issues, and therefore it is, as to those two exhibits, the judge is sustained.
Your Honor, 329 to the court roll.
I don't recall that having been played for the jury, quite frankly.
It was, Your Honor. I checked the videotape of the testimony of Ms. Smith against all of these tapes, and this particular tape, as well as the previous one, 328, were played at the very beginning of her testimony. It's a very short segment in which Dr. Oziel is portion that was played is, hi, 1 week is what you have to get all this together, get organized. You finally found something that's right down your niche. You can do the tape duplication. It's your field. You know how to do this. Absolutely.
Yeah, I remember what it says. I just don't recall that being played for the jury.
And in fact, there were follow-up questions after it was played concerning this.
Okay.
I can provide the court with a videotape of this.
If you just show me the transcript where that was played, I think that would be sufficient.
The transcript, you mean
In
during the trial?
Yeah, it should clearly be in the transcript that was
Okay,
played.
I can find that for the court.
Do the people have a recollection as to whether it was played?
No, Your Honor.
Seems, my position is if it was played, then it's, at this point, it should be received. I just will hold off on that until we find out or verify the transcript. But if it has been played for the jury, then it will be received.
Your Honor, we've removed our objection to 328.
Okay. 328 will be received. All right. Did you want to be heard on 348?
Memory serves me correct, 348 is the tape which,
Relationship of Miss Smith with her mother?
correct. And
I've already rolled on that one.
you have, and that tape is being offered again in light of the cross-examination of Miss Smith, which called into question her testimony concerning whether Dr. Ozio was manipulating her and suggesting things to her. So this is offered as corroboration.
All right, the court's ruling as to 348 stands. Ruling under section 352 of the evidence code, 348 will not be received. There are some other tapes that were listed as question marks when we last discussed it, 347 and 349.
Wait, 347 is the transcript as of 349.
Okay.
347 is a transcript of Exhibit 339,
All right.
and 349 is a transcript of 348.
All right, and 339 was received in evidence. Is that right? So then
Yes.
the transcript will be received. That's 347.
Since the court's already excluded the transcript, I haven't checked it against the tape to make sure that it is accurate. These tapes have been edited, and I don't know if 339 is an edited or non-edited, or so before it's received, can we make sure it's comports to the tape?
Talking about the transcript?
Yes, 347.
All right.
And it does seem that if we have a transcript for one tape, but not on any of the others, that the transcript's going to unduly emphasize that particular tape. So unless all the tapes have transcripts, none of the tapes should have transcripts.
Did the defense wish to be heard on that subject?
Well, we have transcripts available for all the tapes, but this is one that we're going to call particular attention to, and I think the transcript for this would be appropriate.
All right, I see no reason to exclude the transcript just because they are not transcripts presently being offered as to other tapes. And 349 is not to be received. Right. Other than the one tape recording that you're still listening to, are there any other exhibits that counsel want to discuss?
Go through the list and just so I'm.
Yes.
Okay.
Judge, before we leave the Smith-Oziel
Yes.
tapes, the court had indicated it wanted a record made of the portions that were played. And I provided a packet, or I have prepared a packet as to every tape that was offered. And I wonder if we should mark these as
Okay.
an exhibit, not to be offered into evidence, but just for purposes of the record.
Yeah, these are transcripts of all of the tape recordings that were played. And as you prepared the transcripts, they represent the words that are actually played for the jury. Is that right?
Correct. There are some transcripts that are complete transcriptions of what's on the tape. And the portions that were not played are simply X'd out in the exhibits in this transcript being offered to the court.
Okay. All
So-
right, then let's just mark that as another exhibit here. And well, let me get my updated list here. .406. 406 is not received. It's just for identification only. All right. And do you want to go through the exhibits? Well, before we do that, are there any exhibits that either side wishes to specifically point out at this point for further discussion that we have yet to resolve?
Your Honor, as we go through the pages, I think there are a couple that I can indicate to the court. We've either removed the exhibit, removed the discussion, and perhaps we can do it that way, just numerically.
All right.
All right, now is 20, there's a new jury instruction offered by the defense. Is 20 received with that
Well,
instruction?
That jury instruction would not deal with that specific exhibit in the way that I had suggested.
Well,
Without
You're talking about their new,
ruling on the instruction, it's at this point, the issue is whether the exhibit is received. That's the diagram of the
crimes,
family room,
yes.
and there was disagreement as to the position of the table. No one ever asked as to the scale, whether it was to scale.
Yes, Your Honor, because the Detective Zoller doesn't know. It's our position that whether or not it's to scale, it's a fair representation of the placement of the sofa within the room, its relationship to the doors through which the defendants passed, and the location of the television set. And insofar as it shows a representation of those items with the understanding that it's not to scale, I think it should be received. And there has been considerable testimony about the fact that the coffee table had been moved. That was one of the last things the jurors heard last week.
Your Honor, I believe that in his early testimony, actually, Detective Zoller testified it was not to scale, and that no scale diagram was ever made by the Beverly Hills Police Department. I have that in my summary of his testimony.
What I'll do is receive Exhibit 20, since it has been referred to during testimony, and an instruction will be given to the jury specifically relating to that exhibit, that it is not to scale, and the position of the table is not in the identical position it was in at the time the police arrived.
Right.
Well, perhaps it would be easiest.
Or counsel can stipulate to that, or
Why don't we just print it on the exhibit, not to scale? The table has been moved, table moved, and just print it in red right on it like a letter.
fine with me if everyone wants to do it that way.
That's fine.
Mr. Burt or Ms. Hanson?
Yeah, I would like to indicate that that it is not an accurate representation of the room or the furniture in it, because there are other pieces of furniture that may or may not be correctly placed or may not be appropriately to scale. So as
Well-
long as there's some sort of disclaimer that this does not purport to be an accurate representation of that room, we should look at that.
Well, I'll leave it up to counsel as to how you want to phrase it, and if there is some dispute, we can discuss that before the exhibit actually goes to the jury.
Not to
All right,
scale.
so modify Exhibit 20 by a notation on it.
All right, Your Honor, the next exhibit is 46. That's withdrawn. The redaction was going to be meaningless. So,
Okay, hold on. 46 is withdrawn.
correct. As to 55, I wanted to revisit. In reviewing Lyle Menendez's cross-examination, the Porsche purchase records were specifically referred to. in front of the Eric Menendez jury. So that particular document should be received in front of both juries and not.
Was that particular document referred to?
Yes, I took it up and showed it to him after an at-bench conference.
Was it read to the jury, or were the numbers set forth as far as what was on the document, or just the document was shown?
It was shown to him as being the representation. In other words, and these are the records you use when you purchase the Porsche on or about September the 6th.
All right, there was evidence offered only before the Lyle Menendez jury about the details of that transaction, and the records themselves relate to the details. Then the court will receive it only as to Lyle Menendez. That's 55.
Now, all right, the next exhibit I have a question about is 61. I believe that 61 was excluded by the court. Is that correct?
Yes.
All right. 96 has been withdrawn. I could not find it in cross-examination or anywhere else.
Excuse me, I have 61 is disputed.
I have a note that I've ruled it not to be admitted.
I believe that was our last discussion. Do we have 96 as withdrawn?
That's withdrawn.
Yes.
Now, 98 and 99 were supposed to be redacted if admissible. Has that been done?
Well, they were going to prepare a summary, as I recall.
Yeah. Well,
No, that hasn't been done yet, but it will be done.
Well, is it going to be used for both juries or just the Eric Menendez jury?
I think that it probably should be used for both juries, Your Honor.
Well, then when will it be done?
Well, we can't take the books out of the courtroom because they have them under seal. So it's a question of sitting here and making summaries of the number of patients that we're seeing at various days.
Why can't we stipulate that the book reading the notes on this Morris can finish that and get it back?
Well, I don't know how long it would take if she does it here. We'll see how long it takes to complete our work today as to how much time she'll have available today. All right, the next,
117 through 19, people remove their objection.
I'm sorry, what?
117 through 19. Has that been done already?
no,
Okay.
Yes.
I don't have any indication. Well, these were things that you had discussed late last week and you hadn't told me about, so. 117, 118, and 119,
Correct.
okay.
Then I think the next area of dispute is we're down to the 120.
Excuse me, Your Honor, before we go, could we return to 109, which is the Oziel disability insurance claim?
This was
Yes.
discussed in a closed courtroom.
It's been sealed, and it's, yes.
I'm just going to refer to it generically,
Yeah.
but at the time that evidence was offered, it was offered under People versus Wheeler as some indication of prior bad acts amounting to a misdemeanor. But during the defense case, Lyle Menendez testified and Eric Menendez testified similarly. This is at page 14,744 of the transcript in reference to Oziel expressing an interest in the estate, and Lyle Menendez answer concerning a question on that is, he said that he was under a tremendous amount of stress since my brother had come to him and he couldn't sleep, and that he was going to have problems working in the same way, that this was a very heavy burden for him, and that he was going to be getting and that we were going to be getting all this money, and he was a good businessman. And it's our position, Your Honor, that aside from the Wheeler offer of proof that we made, that these records are corroborative of the testimony of both Lyle and Eric Menendez concerning Dr. Oziel's statement that he could no longer work as a result of the threat that he supposedly received. And the fact that this claim was filed and at the time that it was, and the specific incident that's pinpointed in that claim as to the reason for his disability is directly corroborative of Lyle Menendez's testimony.
The court's ruling is that under Section 352 of the Evidence Code, the potential for confusion of issues and is substantial, and the probative value is outweighed by its potential for prejudice and confusion of issues. Therefore, it will be remain sealed and not received.
And Your Honor, as to 98 and 99, I don't understand exactly what the redaction is supposed to be. Is it just supposed to show the defendant's appointments, or the defendant's appointments in relation to other people's, or?
So I understood you, Ms. Morrissey, was going to write a list of all the defendant's appointments throughout the time period.
All right, because if it's just the defendant's,
No, it's not that. The point of it was, during his testimony, I cross-examined him about the number of patients he saw on a given day in order to cast doubt upon his statement that he would write up his notes after the sessions or at the end of the day. And the purpose was to show patient overload. And I think, we were just discussing this, I think I only took him through 1989. So if that's true, then we only would do it for 1989.
and then Your Honor, if that's the theory of why these should be admitted, people would still object. That's pure speculation that as to what the standard of care is in the community for how many patients you can reasonably see and still write notes. It seems to me that under 352, that kind of argument should
Well, I'd have to see what they produce, so until I do that.
The records were also,
Standard of care, I think it has to do with simple clock.
Yeah,
How many hours a day?
the records were also used to show that on the day after October 31st, Dr. Oziel saw, I believe it was 9 patients.
All right. All right, what's the next exhibit?
Next exhibit in dispute is 120. And Your Honor, at this time, we would offer them as to both juries, not just the Eric Menendez. Those were the letters written by Ms. Smith, which were originally read by Mr. Kuriyama, court recalls, during the cross-examination of.
You say you're offering them as to both?
Yes. I believe I discussed those with her specifically during her testimony. We went through the dates and through the handwriting on them and things like that.
What's the defense position?
I believe the letters were explored in front of the Lyle Menendez jury, both on cross-examination of Dr. Oziel, or redirect examination of Dr. Oziel, as well as on cross-examination of Ms. Smith.
So the defense has no objection,
Lyle Menendez doesn't.
and the Eric Mendez.
They're already in front of our jury.
All right, 120 is received.
And therefore, we're going to remove our objection to 122.
Okay. What about the other items here? 121.
Defense is objecting, Your Honor.
121 was marked, as I recall, by the defense and used by the defense, and it's cross-examination of the witness.
Your Honor, I don't think it was marked by the defense. I think it was, however, used by the defense in cross-examination to show that there was a shotgun that was provided to Judalon Smith. So we'd withdraw our objection.
Is that as to both defendants?
Yes.
Okay, 121 will be received. And
Your Honor.
123 and 4.
Your Honor, it's a hearsay objection, especially the accusation.
Well, the accusation and the stipulation were read verbatim to Dr. Oziel when he attempted to characterize it on redirect examination as a technical violation. And he was cross-examined on the content of both, and it was read during his cross-examination, both the stipulation and the accusation.
Was the entire accusation read to him?
Yes.
What is the people's response?
It's still the people's response that the jury should not be, just because something was read to the witness doesn't necessarily make the object admissible. And it seems to me that to reemphasize the accusation, especially by having the jurors read those allegations, which are only allegations, would be more prejudicial than probative.
Let me see 123, 124, and 125, and 126, please. All right, anything else?
No, Your Honor.
All right, to the extent that this evidence was received through the testimony of the witness and the documents were read to the jury and to the witness, and he testified about them, that's already before the jury. There is a lot of material here that is extraneous, and it carries with it all sorts of things that weren't read to the jury. The entire documents weren't read to the jury, at least not to my recollection. And even if they were, it's in the record, and the jury can evaluate it. But the material basically contains much extraneous matters that should not or have not been brought before the jury, at least to my recollection. Therefore, unless counsel can point to me in the transcript where every word was read, I'll sustain the objection to the receipt of these exhibits. It's one. Yeah. And 125 and 126, did the defense wish to be heard?
Those letters were offered in contradiction to Dr. Oziel's testimony and in corroboration of Ms. Smith's testimony. The letter of Ms. McPhee is a letter written by Dr. Oziel attempting to use a tape recording that he had made with Ms. McPhee's voice on it and using it on the face of the letter for some sort of extortion purposes. And the letters from Ms. Curry indicate the type of manipulation that was practiced on Ms. Smith, as well as Dr. Oziel admitting to prescribing Prozac for this individual, which is also relevant to Ms. Smith's testimony concerning a similar MO with respect to her.
All right, the court sustains the prosecution's objection to 125 and 126 pursuant to Evidence Code Section 352. They've already been discussed before, but the court will exclude them at this time. All right.
Okay, the next thing is 174. I just wanted to clarify that 174A is what was received. That was the one, it was the, Ms. Morrissey redacted that. So it would be 174A, I think, that's received.
That's what was going to happen. I invite counsel to review the exhibit and verify that it has.
It has, Your Honor. I've reviewed it. I Xeroxed it for her.
Okay. But again, as to the exhibits before they go to the jury, counsel are again directed to review them to make sure that the clerk has correctly marked the exhibits that go to the jury, and so there's no problems once the juries begin their deliberations.
My understanding that 183 and 84 were withdrawn, and that 189 has been received.
Yes.
197 is for Eric only, and A and B were received.
Yes.
Okay. The next is 256. And did the court rule on that already?
Mm-hmm.
All right.
We're going to redact.
It was going to be redacted so that we're just the top and the bottom of the page.
All right. I still have to do that then.
And you're also, Your Honor, that was also something that was just admitted as to Lyle Menendez.
Yes.
Right. Yeah, it's on there. It's just.
Yeah. 256 is for the Lyle Menendez jury only.
Okay. 297 and 98 were received, correct?
Yes.
Okay. And then 328 were removed. Did I tell the court that we're removing our objection to 328?
Well, I don't recall if you did or not, but
All right.
you are
Yes.
328.
Yes. But I believe that, okay,
Your 328 will be received.
all right. Now, can we back up to 326 and 327?
Yes.
Okay, 326 is we've not yet arrived and agreed upon a transcript to give to the juries for the 1211 tape. And so I don't know, listen to us. I don't know what we've given the defense our version. We've not heard back except that it's in progress. And it seems to me that at some point, we're either going to have to give our version and their version or an agreed upon version.
Your Honor, I think that we're going to be able to reach an agreed upon transcript. Apparently, the prosecution has an enhanced copy of the 1211 tape, and that's why they're able to hear things on it that we simply can't hear. I've asked Mr. Kuriyama if he would let me listen to his tape so that I can resolve these differences. They're very minor. There's nothing of any major significance in the two versions of the transcripts, but I would like to resolve it.
Well, obviously will have to be resolved since the transcript at some point would go to the jury. If you can't resolve it, focus on those things that are in dispute and give it to me.
If I hear the prosecution's version of the tape, I'm sure we can resolve it for sexual.
All right, we were just asked this morning, so we haven't been able to get to. 327, in light of the stipulation I entered into last week, I'm going to remove our objection.
All right, 327 is received.
Okay. Now, 329, did the court, did we just do that? We just did that, but I can't remember.
329 was something we had just discussed. Let me get my other list here. 329,
Court wanted verification that
yeah,
in fact.
that was the one that Mr. Burke was going to look at the trial transcript.
All right. All right, Your Honor, as to 330, that's the business cards of Dr. Oziel.
Yes.
There was no testimony as to what period of time those cards pertain to, and so the people would object as being sort of a lack of foundation, irrelevant objection.
So about 330?
Yes, the Xerox copy of Dr. Oziel's business cards.
Okay, it's sort of cut off on one of my.
I'm going to have someone retype this.
Those were provided to Ms. Smith, and Ms. Smith knew Dr. Oziel at the same time that the Menendez brothers did, so.
Yeah, she described. She described them.
All right, so is that received?
Yes.
All right, and the compilation of phone records she did, the court will look at them. They have notations by Ms. Smith where she argues that Dr. Oziel lied and things like that.
Those will be offered with the all comments redacted.
All right, assuming that's done.
No, and it's still the foundational objection, Your Honor. I believe that Dr. Oziel's phone records already are in evidence. So I don't think that this particular argumentative compilation needs to be given to the jury.
But these also take into account her phone records, which are calls emanating from her house to Oziel.
This is her list of all the phone calls both ways.
Yes.
And there will be removal of all editorial comment from the.
Correct.
Okay, if that is done and it's shown to the prosecution and they agree it's been done, then it'll be received. So I'll mark it received with the understanding it's up to the prosecution to check with the defense to view the documents.
336 was received as to pages 1, 3, 15, and 16, correct?
Well, there are certain pages offered and the one that is not received was page 5.
Correct, okay. .342, the people's objection is removed.
All right, 342 is received.
We still object to her medical records because they contain many hearsay statements that are irrelevant to any issue in dispute in this case. In addition, one of them, I think, contains a letter from one of the physicians to Dr. Oziel thanking him for the referral, which we would object to as being irrelevant.
And is the defense still offering 343 and 344?
Yes, it's
Okay.
cooperative of Ms. Smith's testimony. And we would remove the referral letter.
Let me see 343 and 344, please.
I need to see 345.
The specific portion of 343 and 344 that was referred to in Ms. Smith's testimony was that she was not suicidal when she was brought into the hospital by Dr. Oziel.
You mean the medical records show that?
Yes.
That was 345 or 344?
Yes, Your Honor, there's a mistake on this 345. If this is the original,
Well, hold off on that.
okay, I will. It was a 345. Okay.
All right, as far as 344 and 345, 343 rather, and 344, they'll be received. There is no referral here or letter regarding a referral on this. All right. And you wanted to talk about 345?
No, I was in error. 351 is the next disputed item.
Excuse me, it's the 346. There was no objection by the people to the
That's, I already, I said,
receipt of those portions of the body wire which were played for the jury, but we would be offering the entire tape into evidence
and we would object to
as a
that.
prior inconsistent statement of Dr. Oziel.
The court will receive only those portions that were played for the jury as far as 346. Have you prepared a redacted version of that?
Yes,
As said now in evidence is 346?
yes, that's the edited version is the portion that the prosecution is not objecting to.
Okay. All right, the next exhibit?
Next exhibit in dispute is 351, and that's 345 was withdrawn by the defense. That was the original affidavit, and then the court provided us with 345 was the affidavit shown by the defense to Ms. Smith, which is not similar to the one in the court file. And we would offer 351 as prior consistent and inconsistent statements of Ms. Smith.
Well, we object to the consistent portions as hearsay.
We would object, Your Honor, to the entire affidavit since not all of the affidavit was brought out during her examination.
Yes, it was, those portions that were read to her are before the jury, and those portions will be received in by way of testimony already being presented to the jury. If there is some specific value in those portions that were read, such as corrections made by Ms. Smith or something of that nature that the prosecution wants to present to the court, I'll consider that. But at this point, the statement was read to the jury, and those portions of it that were read are
Your Honor,
will be received, not the document itself.
If I understand you, Your Honor, you're saying that the portions that were read, the jury's already heard, so they don't need the written version of it?
Yes, unless the prosecution
Wants to
looks
show
at the
corrections.
document and says that there are things in there that have some relevance, and I'll review it again, just as we've done with other exhibits, if there's something specific that hasn't been brought to my attention. At this point, it's been read, and she's indicated her response when it was read. All right, which is the next exhibit?
352 is the 6-page rape police report offered by the defense. People would object to that as being hearsay.
We offer that as a prior consistent statement, as well as for the non-hearsay purpose of showing that she did make a complaint concerning the charges that she leveled against Dr. Oziel during her testimony.
All right, under section 352 of the evidence code, the court excludes exhibit 352.
We knew that would happen.
353 is the one I'm listening to. It may be fine. I just have to finish listening to it. And then 354, we're having, it's the same as 326.
What do you mean?
Well, it's still a transcript problem.
Oh, okay.
I think I have a typo on
Okay,
one
that's
of
just
those.
another transcript of the December 11th tape. We have
Correct.
3 of them floating around, is that it?
Yes.
Okay.
Two
Or
are for
four.
jury, but there's 3 of them
Yep.
floating around.
Is, okay, the next thing I want to check, 377 was excluded, correct?
Yes.
All right. And then 386 through 389 have been received, correct?
One second.
Okay. And 390 is E only, right?
389, 90, and 91 are.
386, 87, and 88 were received. 389 was received as to Eric Menendez only. 390 was sealed. 391 was not received. 392, 393, 394, 395 have been received. And that's as far as we've gotten. And then-
396, no objection by the people.
All right, 396 is being offered by the defense. It'll be received.
397 was marked by the prosecution. It's a large photograph of Eric Menendez's bedroom. Is there an objection?
No.
Okay, so
It'll be received.
398 are the 3 names written by Grant Walker. That was supposed to be Xeroxed or some, because counsel inadvertently made notations on the exhibit. So has that been fixed?
It just needs to be Xerox,
All right.
and the Xerox substitute will be written.
398 will be received.
No objection by the prosecution to 399.
All right. 400 was offered as to the Eric, no, 400 was an exhibit marked by the
Prosecution.
prosecution and offered as to Eric Menendez only.
Yes, that's the American Express records.
Yes, there's no.
All right, that'll be received. 401 is a chart
That's fine.
offered by the defense. It'll be received.
Your Honor, that was, 401 was it to Lyle Menendez only.
Okay. 402 is the videotape made by Mr. Peckins. There's no objection to that.
All right, it'll be received.
The Michael Jackson tape, there's no objection.
All right, that's 403.
Mm-hmm.
That has to be
That
redacted
has to be redacted.
so that we just have Mr. Walker's voice on it and Mr. Jackson's voice and not anything that occurred before or after.
Your Honor, the only thing I would ask that is that it starts with Mr. Jackson referring to him as Fred. So I think that's relevant to
Yes.
the defense argument.
Yeah, well, the jury heard that.
Yes, that whatever was played for the jury and that portion only will be received.
404, may I have a moment? 404.
That's not received. That was something marked by Ms. Abramson, and then it was determined that it had not been referred to in, or it had been redacted from the September 17th tape recording. So it is not received.
What, 404?
Yeah, that was the day
That was
during a travel
404.
reference. to
Eric Tam
Tam,
document.
reservation.
Okay, so that's
First.
not received. And then 405 is the Baylor Air Patrol schedule. No objection.
That's E only.
Right. Is it? 405 is Eric Menendez only,
Right.
and that is received.
All right, and then 406 is just for identification only.
Okay.
And that's where we are on exhibits.
And there's one more thing. Mr. Kuriyama is going through the photographs right now and singling out the ones that we would like to offer into evidence.
Also, the
And they will be attached to the radar.
Is it that you're going to be ready with that?
we may want to.
15 minutes, Your Honor.
All right, we'll take a recess. I want to finish reading the document filed by Eric Menendez's counsel on instructions, and people can finish going through the exhibits and any other exhibits that are still in minor dispute here. You can resolve those as well. Anything else regarding exhibits other than what we've already discussed here?
Your Honor, first of all, is it the court's intention to discuss jury instructions as to both defendants today?
At least to a certain extent, yes.
All right. Secondly, what does the court want me to do with the exhibit list vis-a-vis the jury? In other words, I have not heard from the defense that any of the language is argumentative. What I was planning on doing is preparing one list for one jury and one for the other, obviously taking out everything that doesn't pertain to that jury and taking out everything on the right-hand side. So it would just be the number and what as a brief description.
Right, as to those exhibits that were actually received, not to those that are not received.
Yeah, right.
Yeah.
The only thing they're going to have access to.
Right.
Yeah. Is that acceptable?
I just, did the prosecution take out the reference or the description of a certain photo of Eric and Lyle in Sunday best?
Well, you
I
can
can do
discuss that and
All right.
refer to any thing that. Yeah, and it doesn't have to be done prior to argument, obviously.
Right,
Get your
I
arguments
can't.
finalized, and once the jury start their deliberations, then you can get the list prepared.
Okay.
Obviously, for the Lyle Menendez jury first, since they will be deliberating first. And the list will be a little different for each jury.
Correct.
Your Honor, I've also brought in today and given to the prosecution typewritten versions of the letters, Mrs. Menendez's letters, so that we could have those along with the handwritten versions, which are difficult to read. And I think Mrs. Bazanich is going to take a look at them, and
Yeah, that's
if
fine.
they're acceptable, we would put those in under the same exhibit number.
Okay.
That's fine. I just want to read them.
Anything else regarding any exhibits that anybody wants to discuss other than what few things we've mentioned here that are still in dispute and the photographs that the people are looking at? Nothing else?
No.
All right, because I want to get the exhibits resolved prior to going into the instructions, so we don't have to keep going back and forth on it. All right, we'll take a recess and permit everyone to get ready for the next discussion of exhibits and then discussion of jury instructions.
Is now giving me the reference for where Exhibit 329 was played for the jury, and there was some discussion. So does the court need the reference, or?
Was it played?
Yes.
Okay, no, I don't.
All right, so that should be received then, I suppose.
All right, as I indicated, as long as it's verified that it was played, then it'll be received.
It was.
All right, anything else?
Your Honor, I'm still in the process of getting all the notations for the affidavit, 351. So I need to complete reading that. There was extensive cross-examination of her. So can I give that to the court at 1:30?
All right,
A handwritten citation to all the pages and what I want to offer to the court.
okay. Or if you just want to Xerox it, yeah.
Okay.
Isolate what it is that you want to have actually received the documents itself.
Okay.
What about any other exhibits?
And with respect to the photographs, I've reviewed the 4 notebooks provided by the defense. There are approximately 985 photographs in these notebooks. I first asked that the court allow the people to mark these as exhibits, all 4 notebooks,
For what purpose?
for the purpose of showing the relationship between the parents and the defendants, demonstrating how the parents were not terrorizing, that they were not neglectful. There's photographs of the brothers with safety equipment on, with warm clothing on in cold weather. There's photographs of birthday parties just about every year. I believe there was testimony that these boys were so neglected that they didn't have birthday parties. There's also testimony that from the defense that the mother didn't want Lyle as a baby. There's a photograph of Lyle as a baby and a letter that went out apparently as a birth announcement that the proud parents, Kitty and Jose, that went to the relatives. There was testimony by experts for Eric Menendez that there was no cuddling. There are photographs of the mother cuddling both brothers. I think this goes to show that there was evidence that their experts looked at that they simply closed their eyes to or misrepresented to the juries as to what those photographs showed.
You're offering all of these photographs?
Well, that would be my first request. I have, Your Honor, taken a look at the photographs, as I've indicated, 985 photographs. I've selected 89 of those 985 photographs. So if the court were not inclined to allow all 4 notebooks in, I have selected 89 and I've marked those.
Your Honor,
Yes.
there's one other thing. It would also be offered not necessarily, not only to contradict the testimony of the experts, but also to contradict the testimony from all of the relatives and friends who are trying to portray a picture of the defendants, which we believe these photographs show to be exaggerated. And that we think these photographs contradict the image thought to be portrayed by the witnesses in the case, not just the experts.
And has the defense seen the specific
Yes.
89 photographs that you've,
Mrs. Abramson has, and so has Mrs. Lansing.
and what is the position of the defense?
Well, we object to this raid on our resources to begin with, Your Honor. Secondly, a photograph does not tell you anything unless it's explicit, such as the naked photographs that we put into evidence. No one testified that the defendants didn't have birthday parties. No one testified that they never smiled. And to put on a photograph and for the prosecution to argue this shows cuddling, when I happen to know that the very photographs they're talking about are the ones where our experts said she held Eric like a package, makes it obvious that photographs need interpretation. At least these do, the ones they're interested in. So we don't feel that putting in the photo, we object to all 89 photographs. If they're allowed to put in those 89, then there's at least 200 others that, would seem, by reading things into them, which is what the people would do with the 89 they're requesting, to be contrary to the inferences they're trying to raise. But the bottom line is a photograph by itself, unless it shows something explicit, is not very probative and doesn't really prove the things they're trying to prove. It's obvious that Jose Menendez was not molesting his son in front of a camera. At least we haven't found any photographs that he may have taken when he was. And it's obvious that you don't take pictures smacking your kids around. But the relatives who were present at many of the events that are depicted in these photographs and describe those events, nevertheless saw conduct that isn't captured in the photos. And we think it gives a false impression for the people to select 89 photographs that they think show something, when there's no testimony to show that they do show what they think they show. And all they're inviting the jury to do is to speculate on what these photographs mean. And moreover, to pull them out of context. I mean, there's other photographs that were never even shown to the experts, probably thousands of them. Should we put in all 4,000? And then the jury can decide how many are happy, smiling, and how many are sad. And then speculate that the way people behave in front of a camera is the way their lives really are lived. I mean, the whole story of this family is secrecy and false front. So I don't see that these photographs contradict anything that the defense has presented. I think they invite speculation. I don't think you can put them in without explanation or without foundation.
If they've had 4,000 photographs that they could have put on, that was their choice not to put those on. But to put on witnesses to reflect on what these photographs demonstrated to them in terms of their expert witnesses, I think it's up to the jury to decide what the photographs show, and not to an expert to color what these photographs demonstrate.
For one thing, Your Honor, only one expert testified as to one fact, which is that there were no photographs that showed any real cuddling by Mrs. Menendez and the babies. And there aren't any photographs here that particularly do that. In fact, it wasn't even cuddling. It was interaction was the question. And even the photographs that people want to mark do not show her ever looking at or interacting in any meaningful way with the babies. And that was the only subject matter that an expert offered an opinion on. The expert was asked, did you see family gatherings? Did you see vacations? Did you see holidays? So we admitted there were such events. But the only thing that was commented on was the manner in which Mrs. Menendez in these photographs appeared to be non-interacting with the babies, period. And there aren't any photographs here that show any real interaction anyway, so there's nothing inconsistent. But to just put on photographs and argue their meaning without any expert testifying to it, any witness to the events testifying to it, is not relevant.
Ms. Lansing, did you wish to be heard?
Yes, Your Honor, thank you. I think I have an overall general objection to just putting them on wholesale for some of the same reasons Ms. Abramson has indicated, which is the lack of anybody there to narrate them and have some application and some interpretation, which could then be cross-examined. So this sort of sends it in there for everybody's best guess. I have some specific observations. One, there are pictures of Christmases, and I think Lyle Menendez in his first day of testimony did indicate that one of his best memories about his mother was that she got up with him on Christmas morning early so they could open packages. So it certainly doesn't contradict that testimony. There are pictures of vacations, and they have talked in detail about vacations and been cross-examined about the fact that they took ski vacations and beach vacations. So there's nothing contradictory there. With regard to birthday parties, as I recall the testimony, there was testimony about birthday parties and that they were usually celebrated with the relatives, and there's certainly a number of those photographs. We ourselves put on the 6th birthday party pictures of Eric Menendez as they were on the same roll as the two naked photos. So I'm not sure what it's all supposed to prove. I think it was triggered by, I believe, Dr. Tyler's statement about Kitty Menendez holding Eric as a package, which is something that was never in front of our jury. So if all of a sudden they have a bunch of pictures of Kitty Menendez holding Eric either as a package or not as a package, it's not going to have any meaning to our jury. So I think that it will be unduly confusing to just send in 90 selected family photos. So we would be objecting to them.
You know, I have one in particular that I think is quite important. There's a photograph of Eric Menendez that it says in this notebook, Lyle's 7th birthday. It appears that he's holding a camera. Now, they've put on evidence that there's 2 photographs at Eric's 6th birthday where it appears that young boys took the photographs, but yet they will say that the father took this photograph. They've got 4,000 photographs. Apparently, they have no other photographs which indicate anything like that. They probably have photographs which indicate that where the subject matter is off-center to demonstrate that the children took photographs on occasion. But I think this photograph in particular shows that it was probably the brothers themselves that took the photographs. So I think these photographs are important, not only for that particular reason, but for the reasons, as I've stated, that they've tried to put on experts to say that these defendants were neglected, that they were terrorized, that throughout their lives they got no love. I think that's misleading, and I believe that these photographs will dispute that.
All right. The court does have before it the testimony of the witness Tyler, Dr. Tyler, that has been a subject of discussion. She was a witness called on behalf of Eric Menendez, examined by Ms. Abramson, cross-examined, and then redirect examination. The initial direct examination on page 17620 asked the witness what other information did she have that demonstrates that Mrs. Menendez denied the defendant emotional needs. And the witness answered she looked at photographs when he was a baby. And then the question is, what did you see in the photographs? And then the answer, something about handling like a piece of baggage. And the witness went on and said, I couldn't find any pictures of the mother and the child with any cuddling, any real close. They just stood out. I think that it was remarkable, for me anyway. Then on cross-examination, the witness indicated that at page 17781, the witness indicated that she had viewed family albums. On redirect examination at 17938, the witness on redirect examination was asked, did you look at numerous family albums in my office? This is by Ms. Abramson. Answer, I did. Question, and did you see photographs in there of many family gatherings, Christmases, Thanksgivings, parties, those things? Answer, yes. Question, did you see many photographs of the family on vacation and scenic photographs of pretty places? Answer, yes. Question, did you see school photographs of the children? Answer, yes. And were there photographs of both parents with Eric and Lyle when Eric and Lyle were very, very young? Answer, yes. Question, and did you look at all of those photographs that you could find of where Eric was quite young and with his mother? Answer, yes. Did you see any photographs in which she appeared to be interacting with the child? Answer, no. Do you remember seeing any photographs of Jose Menendez with Lyle when Lyle was real small? Answer, yes. Do you recall any of those where Mr. Menendez seems intensely focused on Lyle as a baby? Answer, yes, I do remember that. Question, did you ever see such intense focus by Mrs. Menendez with either of the babies? Answer, no, I did not. And that's the extent of the examination of that witness regarding photographs. Based on the offer here or the request of the prosecution, I have no choice but to look at the photographs to evaluate them. They've been identified, I see, by some tags. I'll look at them. The one particular photograph that you referred to regarding a camera, is that separately identified there?
I will separately
I'd like to see
identify
that
for
one,
you.
Mr. Tran, 'cause
Your Honor, so is this issue limited to Eric Menendez this time since Ann Tyler did not testify in front of our jury?
I believe that there was testimony in front of Dr. Conti about pictures, and Mr. Kuriyama has that segregated, that testimony.
Yes, Your Honor.
All right, that was not presented to me. But first, let me look at the photographs.
Okay.
In regards to the photographs, I did review them. I've made some red notations with red ink on those tabs that were put on the photographs by the prosecution. Those are photographs that can be the subject of further discussion.
Is this Eric Menendez only or both, or where are we?
As to both, the photographs in their totality do seem to portray things in potentially different light than some of the evidence offered by the defense, but I don't see that as being grounds to receive each and every photograph. Some of them might have relevance specifically to certain issues in the case, and those are the ones that we can discuss further. I don't know where they are now. They were given back to the parties.
Oh, there,
All right, we can discuss that a little later. If anything else regarding exhibits?
Just briefly, as to the photographs with regard to Lyle Menendez, Mr. Kuriyama has pulled the transcript references to photographs, and there appear to have been two, both of them by the prosecution. There are no references by the defense to photographs, and they appear on 18991, which was the cross-examination of Dr. Hart, in which Mrs. Bozanich asked, did you ever look at any family photographs or family memorabilia? Yes, I did. How many photographs would you say you looked at? Oh, it would be just a very rough estimate. It was maybe 1 or 2 books full of photographs, so it might have been upwards of 50, I suppose. I don't know how high that may have gone. There were a lot of them. Who provided you with the photographs, Ms. Lansing? So that's the only reference to photographs with regard to Dr. Hart. And the only reference to photographs with regard to Dr. Conti was on recross. Mrs. Bozanich said, did you look at family photographs? And he answered, some.
Yes, the only observation I have is that the defense used certain photographs in its presentation of its case. And if there are other photographs that relate to things that are relevant to the photographs used by the defense, then those photographs might also be relevant. And that's why I marked certain photographs that very few, actually, not nearly as many as the prosecution had marked. We can have you look at those and discuss them further. Anything else regarding exhibits other than that? All right, then let's turn to jury instructions. I know counsel want to resolve them so that you can complete your preparation for your arguments. The court has received from both the defense of Eric Menendez and from the defense of Lyle Menendez written memoranda relating to the issue of self-defense. The prosecution has filed no brief. Other than what the defense has put in writing, is there anything else that you want to state to the court on the subject of self-defense?
I, for one, would like to hear what the position of the prosecution is, since they didn't file any responsive pleadings. I'm unclear whether they are still objecting to unreasonable self-defense or whether the objection is just to perfect self-defense. And if so, I'd like to hear what their
I think
position
that's
is.
an appropriate request.
Yes, Your Honor. Having relied on the Eros case, I think that I find a logical flaw in the Eros case, but that does not invalidate my reliance on it for self-defense, but would invalidate reliance on it for imperfect self-defense. In other words, I think that one of the distinctions that Eros makes is about the use of the term imminent. But I think more correctly, it's the people's contention that there has been insufficient evidence that would meet the objective criteria for perfect self-defense. And I believe that Eros, and I think the court indicated, the court would so instruct the jury, indicates that the psychological testimony is not relevant to the issue of reasonableness, but rather only goes to the defendant's belief. And therefore, it's the people's position that under Eros, which upheld the trial court's refusal to give self-defense instructions, the people would encourage this court to refuse to give perfect self-defense instructions. However, it's not our position that the court should refuse to give the imperfect self-defense. And although it would be an attractive argument, I don't think that it's intellectually honest to so argue, because the unreasonableness goes to lots of different factors, including the perception of imminence. And so insofar as Eris's discussion of imminence in terms of the giving of the self-defense instruction, I don't think that is the correct reason to refuse to give the self-defense instruction. I think the correct reason is that there's insufficient evidence upon which any trier of fact could find that the defendant's perception of danger was reasonable. But in terms of unreasonable self-defense, I think that it would be incorrect for the people to say that Eros supports the people's position that imperfect self-defense should not be given as well.
Well, in light of that concession, Your Honor, it now seems to be the case that the prosecution is conceding that there is sufficient evidence in the record from which a jury could determine that Lyle Menendez and Eric Menendez had a subjective belief in the imminence of a threat to their life, or a subjective belief in the imminence that they were going to be caused some great bodily injury by the parents.
They're saying there's sufficient evidence for the jury to decide that issue.
Correct. That's what I understand that concession to mean. And given that, it seems that the only issue left for consideration on the question of perfect self-defense is whether there is any evidence in the record to justify a reasonable person in the same circumstances as the defendants were in, and that would take into account the entire history that was put before the jury, had reasonable cause to believe that they were in fact in imminent peril to life or great bodily injury. And as we pointed out in the memo, the standard here under Flanell is that doubts as to the sufficiency of the evidence to warrant instruction should be resolved in favor of the accused. So it seems under that standard, the court has to be able to say, there is no doubt in your mind that there is insufficient evidence in this record. There has to be no doubt, otherwise the balance goes to the defendant and the instruction should be given. And just stepping back from the issue for a moment, it seems unwise from the prosecutor's standpoint, and some sort of concession that they really don't trust the jury system, to be taking the position with the court that the court should withdraw this issue from the jury, because if in fact the evidence is so weak that it could not possibly justify an instruction on that, then it should be equally weak enough that the jury will reject the defense under appropriate instructions. And all the cases we cited to the court point out that if the court erroneously refuses to give the instruction on self-defense when there is any evidence in the record to justify it, it is reversible error per se. And it's reversible error per se because such an instructional error implicates the defendant's federal constitutional right to a jury trial. So the people are willing to gamble that in this case, after all the testimony we produce over a period of 5 months, that an appellate court will say there is no evidence whatsoever deserving of consideration in this record which would justify a self-defense instruction. And if they're wrong about that and the court takes a gamble and refuses to give the perfect self-defense instruction, then what we've been doing here for the last 5 months is for naught, because the case will have to be reversed. And if the court, on the other hand, were to play it safe and to give the instruction, the worst that could befall the people in that situation is that the jury would then be confronted with the task of determining under appropriate instructions whether the evidence was sufficient to sustain the defense of perfect self-defense. It still leaves the people open the option of arguing to the jury that under the court's instructions, that defense is not substantiated on the evidence that has been presented. And it seems that although the prosecution is willing to take the risk in the circumstances of this case, that we'd urge the court to be a little cautious on that score, because the implications of erroneously denying a self-defense instruction in this case. And in that regard, I think it's important to point out to the court that this is a case not only in which the defendants and their witnesses testified to a history of abuse and the experts explained the history of abuse, but there is specific evidence in the record that threats to kill the brothers were made under circumstances very similar to what occurred immediately preceding the homicide. Because there was testimony by Lyle Menendez that at age 13, when he had the discussion with his father concerning sex with Eric, that the father told him, "We should just keep this between us or I'll kill you."
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
And then later on, there was testimony concerning an incident with a tennis instructor, I believe it was Mr. Klaus, where Lyle Menendez apparently embarrassed his father in front of Mr. Klaus. And after threatening to kill Mr. Klaus, Jose Menendez said to Lyle Menendez, "If you ever embarrass me like that again, I'll kill you." And the phrasing of that threat to kill becomes significant when the court then turns to the evidence concerning the discussion Lyle Menendez had with his father the Thursday before the killing. Because here's a situation where Lyle Menendez is threatening to embarrass his father by revealing the sexual abuse. And the actions which Lyle Menendez's father take from that point on are interpreted within the light of those prior threats to kill. This is not a situation like Eris, where the defendants claim a remote threat.
No, Ms. Eris said there was a threat that night, didn't she?
Well,
In the first line of the opinion.
That's the key. It's the proximity. It's the enemies of harm. It's the distinction.
The second paragraph of the statement of facts. On the night of the killing, defendant testified that her husband beat her and threatened that he didn't think he was going to let me live till the morning. She believed he was very serious.
Right. And then when she comes back to the house after getting the handgun, the only testimony at that point is, and this is on the next page, I then sat down on the bed and I felt that I had to do it. It would be worse when he woke up. And the implication of that testimony to me is she's sitting at the side of the bed thinking, when he wakes up, he's going to kill me. And so at the point in time when she's sitting there ruminating at the side of the bed that, gee, he's going to wake up, and he had said when he wakes up, he's going to kill me, she pumps five rounds into his back. And I would say that that's significantly different here because there's no indication in the evidence that Lyle Menendez or Eric Menendez said that they believed that the threat was going to take place in the threat to kill was going to be effectuated in the near future. The testimony is clear that their belief was that it was happening now. And I believe, at least insofar as Lyle Menendez is concerned, Ms. Lansing clarified, when did you think the threat to kill, when did you think the threat was going to be effectuated? And he said then. So I think that is a factual distinction between the Aris case, because the way that the defendant testified in Aris made it seem like the threat was remote in time, remote in the sense that it was going to happen when the victim woke up, and you don't have that testimony here.
Are you saying that the only time the reasoning in Aris would apply would be when the victim was asleep?
No, I think the reasoning applies to a situation where the defendant's own testimony does not indicate the imminence of the threat. And I'm asking the court to contrast the testimony which was presented here with what was presented in Aris, where the defendant apparently, by her own testimony, admitted that the threat was only going to take place when he woke up. So there may be other situations where the defendant, whether the victim is sleeping or not, I think the key point is, what does the defendant testify as to the imminence of the threat? If it's threatening to occur, then the self-defense instruction should be given. If there's some remoteness to it, then it should not. And I think that's as far as one can read Aris.
Well, a defendant testifying that something is going to happen, if believed, establishes the defendant's subjective belief.
True.
There is still an objective standard in California. The defense in its brief cites the court to the law of the state of Washington, which is different than this state, although the defense seeks to equate the state of Washington's substantive law with that of this state, and infer that California has adopted the subjective approach that the state of Washington has, although from my reading of the case law in the state of Washington, that state doesn't have the imperfect self-defense law that we have in California, or it appears it does not.
I think the standard is exactly the same. In fact, the court in James, that's the case we cited to the court, quotes their self-defense statute, which is verbatim the same statute as California.
Well, the statutes might be the same, but the Supreme Court's interpretation is substantially different.
I don't think so, because I think the court says it's objective, subjective in the sense that the objective standard takes into account the individual circumstances of the defendant. In other words, in judging objective reasonableness in Washington, the jury is required to place itself in the shoes of the defendant and consider the circumstances in which that person found himself, and specifically the abuse history. And that's exactly the same standard that California has.
California doesn't have that standard. Aris says we don't. That you cannot use the abuse aspect as a factor to be considered. You have combined all the history of abuse and the expert testimony with prior threats, and you combine it into one big conglomeration of evidence and say it all must be considered by the trier of fact, and the trier of fact must be placed in the position of a person who has experienced all of those things. And
Correct.
that is not the law in California.
Well,
Otherwise, you would have a purely subjective standard of proof. And there would never be an objective reasonable man standard in California.
Well, that's where we come to the cases we cite to the court, which is Pena and Bush and Torres.
Those are threat cases, not cases dealing with history of abuse and the psychological effects of abuse that has been offered by the defense. The court indicated that evidence would be received as to the subjective aspect of the defendant's belief, not as to the objective aspect of the law of self-defense.
I think Ms. Abramson wanted to say something, and it's hard for me to concentrate when
Well, if you had something that you wanted to respond to.
Well, I do, but
why don't
I'd
you
like
do
to
that?
defer so that I could concentrate on what I'm trying to argue to the court here.
Well, I'd like to finish off on one subject at a time.
Well,
The same subject.
the only thing I wanted to point out to the court is in the Pena case, when they're talking about whether it was error not to instruct on antecedent threats, the court says, suffice it to say that other reasonable men would view the victim simply as another patron. The victim's entrance and approach would lack the import perceived by one aware of antecedent threats. A defendant's knowledge of uncontradicted antecedent threats must therefore be taken into consideration in the determination of the reasonableness of a belief in the necessity of self-defense. And if that's the law, then that directly corresponds to the law in Washington. Whether it corresponds to the law in Washington or not, it's not really the point here. I think the point is that California self-defense does have subjective elements. Perfect self-defense does have subjective elements to it. And in fact, the Calgic instructions on self-defense talk about viewing it from the perspective of the reasonable man in the same circumstances.
But that doesn't put the reasonable man in the same life history of the accused. If you did, then you wouldn't have a reasonable man. You would have a totally subjective standard that is based upon the defendant's state of mind and nothing else. And that is not the law in California.
Well, then I don't see how the court can reconcile that statement with these cases on antecedent threats, because how can you instruct the jury that they must take into account antecedent threats, which are unique to the life history of that defendant and his relationship to that victim, and still have a purely reasonable man standard? It's our position you cannot, and that these cases stand for the proposition that there is a subjective element, and that subjective element comes into play in this case because the history of abuse is really indistinguishable from the antecedent threats.
Well, I think the distinction is that California does have imperfect self-defense and Washington does not, and that the area that you're addressing is dealt with in the imperfect or incomplete self-defense. Let me hear other counsel's views on the subject.
All right, Your Honor, I disagree with my co-counsel's characterization of the law in California, and I also disagree with him with respect to what the history of abuse and how it interacts. And here's how I analyze it. I agree with the prosecutor that the Aris court had some logical flaws, and I'll get to what those are. But I think where it was not flawed was the notion that abused people may misperceive things as a product of the abuse, but nevertheless are acting in good faith. And so I agree with the Aris court that the history of abuse, to the extent it leads to misperception, is nevertheless relevant and admissible on the issue of a defendant's good faith belief. And good faith belief is the first step in both imperfect and perfect self-defense. However, in reconciling Aris with Pena and Bush and Moore and Torres and that line of cases, I think we're not talking now about a history of abuse as producing misperception, but of special knowledge of prior threats, which has nothing to do with whether the defendant has been damaged by abuse or not, and is no different for abused people than it is for non-abused people, such as Pena, for example, in the Mexican Village case.
In that respect, California law says when there is a history of prior threat, a threatened person in this state can act sooner, which has to do with the issue of imminence. And it is not the Washington standard, which means that all the perceptual evidence having to do with abuse bears on imminence. It is a more objective standard, but it is still a standard that says, if you have been previously threatened by someone, if you are familiar with their animosity towards you, if you have reason to believe based on your individual history with them that they are about to carry out a threat, you need not wait the same as a stranger to be acting reasonably. And I think that's the key to the California cases. Now, in our particular case, Your Honor, this is not a case in which someone who has suffered years of abuse simply decides, I am psychologically blown, I can't take it anymore, this is a form of death, and therefore I'm going to kill or be killed before the next cycle of violence begins. Okay? In order for that kind of case to benefit from to be appropriate for an objective self-defense instruction, yes, you would need the kind of standards that Washington State has. But this is not that situation. This is a case where there is an ongoing argument. This is a case where there have been threats of death as interpreted by the defendants, and that bears on good faith. But threats of death, which now bear on special knowledge, over the course of that entire weekend. And this is a case where, like Pena, these defendants knew enough about the people threatening them to know that they were violent people, to know that they were the kind of people who would act violently to protect what was nearest and dearest to them, which was their values of success and winning and status and public perception. So the only thing that the abuse history here really has to illuminate is the good faith of these defendants. But the fact that there were prior threats, the fact that there was threats within minutes of the killing, and the fact that the parents were in a position, as far as the defendants or anybody else outside that room would know, to act upon those threats, implicates California's objective self-defense rule. When the court asked the question, do you have to be asleep then? Is that the only time when it would be appropriate, when one could clearly say a threat is not imminent? I could think of many other examples. If Mr. Pena, for example, or if these defendants, for example, believed their parents wanted to kill them, but believed that it wasn't going to happen until Tuesday at 1:30, then acting Sunday night would be acting unreasonably. But the question is for the jury as to whether or not, given threats to kill by these parents, violent actions in the past by these parents, and an escalating series of threatening behaviors by these parents, which were interpreted by the defendants in good faith, because we don't get to the next stage unless the jury believes that, as threats to kill, were they absolutely acting unreasonably in the sense that the threat could not be perceived to be imminent? I think the court would agree that you could not say that what they were threatened with was death, that it was unreasonable for them to believe, or that there is no evidence in the record for the jury to consider whether the threat was death. I don't think that's the part of the self-defense law that we're concerned with. I think the question is, could you say as a matter of law, absolutely, that they were totally unreasonable in believing that the threat of death or rape or bodily harm was imminent? Now, here is where the Aris court went off. And Mrs. Bozanich is right. If the Aris court really meant what they said about imminence, they could not have approved the imperfect self-defense instruction in that case. And here is why. An imminent threat does not have to be proven to be actual, factually true. That's not the law of self-defense in any event. A defendant need not have to show that in actual fact it was imminent. Because if that's true, then self-defense would not be available to anyone unless he shot second. It would not be available unless in the shootout.
Okay, we know that part of the law, so you can go
So-
out to the area
so-
of dispute here.
All right, so we're only dealing with the notion of whether it could have been reasonably apparent to these defendants with a history of threats and violence from these parents who are awake and capable and strong and have now secreted themselves, whether they could believe that short of their taking action, nothing would stop a lethal assault on them by their parents. And that's where I think it all boils down to the notion of what does imminence mean. And imminence does not in this state and should not mean immediate for all of the reasons that are in the briefs that were filed. Imminent simply must mean unless you do something, it's going to happen. And it's in operation now. It is in motion. And that was their perception. Now, to analogize it to the Aris situation, Mrs. Aris is sitting on the bed and she is holding a gun. And so she has no reason to believe that she is about to die because Mr. Aris may never wake up. But the situation in that case may have been very different if Mr. Aris did wake up and said something threatening to her. Or
Well, Mr. Aris was going to wake up at some point until he was killed.
But she is sitting there
any
protected.
different than the defendants knowing that the parents would come out of the room at some point?
Yes, it is different than knowing because they did not know in what condition the parents were going to be coming out of that room or how they'd be coming at them. Whereas Mrs. Aris had Mr. Aris in full view. She had the absolute advantage of having a loaded gun in her hand, and she could see the precise moment when his eyelids fluttered, if that was the issue.
Well, wasn't that all the situation the defendants had when they walked out of the house, reloaded, came back in, and walked to the door? The door was still closed?
No, Your Honor. And the reason why not is because they are in that state of terror and fear. Okay.
Okay, is that a reasonable?
Yes. I mean, that's for the jury to decide.
No, that's first for the court to decide whether there's some evidence that would justify the matter.
Well, we have certainly put evidence in that it is reasonable when people have tried to kill you and you are truly frightened. It is reasonable to act in the fight or flight mode.
Okay, that again goes to
That
the
is
good
reasonable
faith
behavior.
aspect of it, not
No.
to the reasonableness of it.
No, Your Honor, I think that the whole law of self-defense, since we do not require a duty to retreat, isn't it always, Your Honor, more reasonable to leave if you have that option? One could always argue that unless you escape from a threatening situation, you are not acting reasonably. But in this state, as a matter of policy or an understanding of human nature and the fact that people can't always choose which of these panic reactions they're going to engage in, the rule is you need not leave, you need not flee, you may defend yourself. Now, Pena could have gotten off the bar stool at the Mexican Village. He was surrounded by other people, and his assailant was a good distance away, and he had not seen a weapon, and yet he was not required to do any of those things before he acted in self-defense. And the same is true here. The jury may decide it was unreasonable for them to have acted when they did. They should have waited till the parents walked out the door with their own weapons. Or they may decide that given the circumstances of prior threats and given the secrecy and the peculiarity of the parents' behavior that weekend, it was reasonable for the defendants to act as they did. Or they may decide that a reasonable person is not a superhuman person. A reasonable person is a person who uses rationality and logic when those functions are available to them as a person, and is also a person who responds to the autonomic nervous system when that is the only response you can expect, or is a person who responds to the actions of the limbic system because you cannot override those things.
All those things go to a subjective reaction, not to the reasonable man standard. It's not the reasonable man standard.
Well, Your Honor, I do not think that is true. Even under a reasonable man standard, we take it to, I mean, look at the notion of heat of passion, for example. I realize that's a different set of instructions, but the point is you're acting reasonably when you panic. There's nothing unreasonable about panicking. All people panic. You're not a peculiar person for panicking. And you're acting reasonably when in a panic, you can't think any more clearly than survive.
The question is, would a reasonable person in that situation have panicked? Not a person who's suffered abuse over a period of time that's caused somebody to have the type of central nervous system response that your witness described. That creates a subjective approach, not the objective approach of the reasonable man in that situation, having been faced with the threats, not with all this prior history that you're talking about.
Prior history of threats, yes, Your Honor.
Only the prior threats.
All right. So the question is whether a reasonable person would panic when faced with a prior history of threats from childhood and when faced with the knowledge of how important to these parents it is not to reveal a secret, when having threatened to reveal a secret and been both attacked and threatened in response. Now, a jury would have to say, and this court would first have to say, it is absolutely unreasonable for these defendants, when faced with these parents. Now, Pena's not faced with an unknown either. This is a given person of violent, threatening propensities. Have to say that it is inconceivable that any reasonable person would think that with this escalating series of moves within this family, with the threat to reveal the secret, with parents who have always been private and secretive, and that's not subjective on the part of these defendants, that's testified to by dozens of witnesses, one would have to say it's unreasonable to think they would kill to stop that. It's unreasonable to think that they're ordering Eric up to his room, that they're telling them they're not going to leave, they're secreting themselves in the den, is not immediately preparatory to their taking action against their sons. And I don't think that that's the province of this court to say that. The heiress court can say that a sleeping person, when the defendant is sitting there armed and in a position of superiority at that moment, that the threat could not be considered imminent. But once the chain of event is set in motion, I think it is improper and unreasonable to say, okay, now you're racing in a panic to defend yourself, but you should have stopped at the doors to the den, or you should have stopped when you ran outside. I think that is asking people to behave not only in unreasonable ways, but in non-human ways. I think the only time that it's appropriate to analyze the reasonableness of the defendant's actions is at that moment on the staircase, when after this escalating series of confrontations with the parents, they perceive a clear threat to their lives. And it isn't a threat of tomorrow, it's a threat of right now. And in order to prevent that threat, they raced around and took certain actions. And I think this court cannot say as an heiress that the situation was totally calm and totally controlled by these defendants. They have no way of knowing how or where and in what manner the parents are going to come at them. I mean, we've seen a floor plan of this house as well. Those doors aren't the only way that people can get in and out of that room. There are many other ways in which they could have been attacked by the parents. The real issue here, though, now is not whether we have convinced this court of self-defense. We, after all, did not waive jury. Not entirely stupid here. But the question is whether there is any case authority in this state that says that short of the unique situation in Eris, one could say as a matter of law that it is absolutely unreasonable to believe there is an imminent threat. As I've said, I don't think there's any question with the nature of the threat as they perceived it to be. The only question is, were they acting reasonably in believing it was imminent? And reasonable does not mean were they right. Clearly, they were not.
Okay, we
right.
don't have to go into the area of law that is not in dispute.
All right.
Right. You proposed certain theories as far as the objective and subjective elements of the evidence offered by the defense. Did you propose any instructions along those lines that would deal with how the jury would distinguish between the evidence offered by the defense in that regard?
I'm sure we can.
Have you? Have you thought of that, or is this something that you just bringing up?
I don't know, Your Honor, because I had not been doing it. I certainly didn't bring up this argument. I've made this argument in many cases before and in front of the legislature as well. But we can easily submit
That's a good place to do that, to the legislature. But this court has to deal with the existing law and the definition of imminent danger that has been set forth by the courts of the state.
I could by 1:30, Your Honor, have an instruction that would distinguish these elements.
Well, I'd like to see what your proposal would be in that regard, certainly.
Your Honor,
Yes, let's hear a response from the prosecution.
what the defense is doing is commingling special knowledge of antecedent threats as outlined in cases such as Pena with particular misperceptions of the defendants in this case, which was the subject of expert testimony. And they've commingled them to the point that they've tried to blur the line between situations such as Pena and situations such as theirs, in which the testimony of an expert is necessary to explain why this particular conduct, which appears to be so unreasonable, could be, in fact, be engaged in by people because of their prior experiences. In this particular case, there are no antecedent threats which are of the strength and nature as those in the Eris case. These particular defendants on occasion were told that their father would kill them. But those particular threats were many years before, and in addition, those threats were never accompanied with the kind of beatings that Mrs. Eris took. And immediately prior, and that would be even in the day prior to the murder of Mr. and Mrs. Menendez, there were no threats of death and there was no beating which preceded the threats of death. So the antecedent threats and beatings and the special knowledge of the defendants are inapplicable to the factual situation in which the defendants found themselves on August the 20th, which is why those antecedent threats and special knowledge are irrelevant. And it's why the defense needed so many experts to come in and try to explain why that which looks so peculiar is understandable. And so it's the people's position that cases such as Pena and antecedent threats are really not applicable to this case because of the fact that those threats and any violence in the past were not repeated in the 24 hours preceding, or even starting on the 15th of August. None of that preceded the killings of Mr. and Mrs. Menendez. And therefore, there's a distinction here. And I'd like to point out again that Mrs. Eris was beaten right before her husband fell asleep. And he said, when I wake up, you're dead. And that beating was something that would put her in fear for her life. In this particular case, what preceded the murders was a closing of a door. There was no threats. There was no violence that preceded that. And therefore, factually, this case is distinguishable from cases such as Pena. I think the purpose of the defense experts was to try to explain that which appears to be inexplicable in terms of the defendant's conduct. And that is why the perfect self-defense should not be given, because these lines of cases deal with antecedent threats which track which occurred later on. And in our case, the antecedent threats do not track what occurred in the days and hours preceding the murders on August 20th.
Well, Your Honor, I think counsel is conveniently forgetting many facts. First of all, my client was attacked with a knife 1 year before this and threatened with death. He was attacked Thursday night by his father, who reminded him that he had threatened to kill him if he ever told. And Lyle was also threatened by his father that night, told in effect. I mean, there are no specific words of threat that have to precede an act of self-defense. But Jose Menendez told Lyle, you chose your course and Eric chose his, which was a very ominous thing. And I think anyone knowing Jose Menendez, not just his sons, would find it ominous. Jose Menendez banged on his son's door Saturday night, clearly angry and upset with him. And the bottom line is, immediately preceding the defendants taking action to defend themselves, Jose Menendez ordered Eric up to his room and said he'd be there in a minute to deal with him. And I don't think, given the history of this family and given the history of his behavior towards Eric and his using sex as punishment in the last 3 years before he died, that anyone would consider it unreasonable for Eric to anticipate another attack, at least as similar to the efforts that Mr. Menendez had tried to make Thursday night. But more importantly, the fact that all of this information in this, that everybody knew, if you will, and that these parents still did not feel compelled to talk about things with their kids, indicated their incredible sense of power over their children. And I think ordering Eric to his room and Eric going up those stairs, Jose Menendez still believed he had complete and total power and control over Eric. I think Eric recognized that that's what his father felt, and therefore Eric's belief that what awaited him at the top of the stairs was an act of sodomy was not unreasonable. It fit the pattern of how his father controlled him before.
Was it imminent as defined in Eris?
Well, but you see, that's where Eris messes up, Your Honor. In Eris, imminent means actually about to happen in a factual sense.
Well, when you say it messes up, it says that's the accepted and longstanding law in California. And
Then
Mrs. Eris was sentenced to 15 years to life in state prison for second-degree murder, and the Supreme Court had an opportunity to review that opinion and denied hearing.
But the point
So that's
there
the
is,
law of this state.
I understand that, Your Honor, but they said that same imminent standards applies to the Flanell defense, and yet he's just as asleep when the Flanell instructions were given in that case, and the court approved the giving of those
Right.
instructions.
Could I add one
That's
thing?
still the law as far as the definition of imminent danger, whether the defendant benefited or didn't benefit from the flannel instruction.
Well, but the
Could I
point
add
is,
one thing factually when you're done?
if we change imminent now to mean immediate, is 1 minute imminent? If the father had said, I'll be there in 2 minutes, would that not be imminent? I mean, I think the problem is, the real issue is whether the events are in motion and will not cease to be in motion absent intervention and effort on the part of the threatened party to
Doesn't
stop.
closing the door cease any motion?
Oh, no, I mean, the way, you see, the importance of the expert testimony was that it explains the defendant's hypervigilance in reading of cues, not
Okay,
that
now you're going against
No,
the
no.
subjective standard.
it has to do with their good faith belief.
The subjective standard of good faith belief, not the
But good
reasonable
faith
man.
belief in the danger, not in the imminence. The point is closing the doors where the parents are now behaving, have taken a place of concealment, if you will, and yet prohibited their children from leaving the house, okay, does not stop the notion of imminence. It's what put the last match to the fire of it.
All right, Mr. Burt, you want to?
Yes, just to respond factually and to add what Ms. Abramson has already said, and viewing the circumstances from the objective standard that the court seems to be focused on here. Thursday evening, during the confrontation with Jose Menendez, Jose Menendez tells Lyle, this is at page 14568, don't throw your life away, just stay out of it. And that's in reference to don't throw your life away by revealing the sexual abuse and stay out of it. Late Saturday evening, when the brothers come back from UCLA, this is following the fishing trip, there's a confrontation with the mother who lets them in the house. And she turns to Eric Menendez at that point and says, if you had kept your mouth shut, things might have worked out in the family. And both brothers testified that in the context of this series of confrontations, to them that meant that the decision had been made that they were going to go ahead with their plan to kill the brothers. Sunday morning, Lyle Menendez learned of the confrontation which had taken place with Eric Menendez Saturday evening after the words spoken by the mother, in which the father had been pounding on the door. And Lyle Menendez testified he couldn't have been more nervous because of learning of this incident with the father and his mother's comment on Saturday evening. And then Sunday, Lyle Menendez goes in and attempts to engage in conversation with his father about a tennis camp over in the marina. And the father says, what does it matter anymore? Lyle Menendez also testified that he later learned in the day that Mr. Menendez had lied to a friend of his about Lyle Menendez being home, and he testified about the significance of that lie was that the father wanted him home that night so that he could kill him. And there was also testimony that Jose Menendez, through an example, preached a philosophy to both brothers concerning the Chinese students who were rebelling in China, and indicated to him that his philosophy was just acquiesce and then kill them. So these are circumstances from which a reasonable person, given the antecedent threats, could say that an act of acquiescence by Jose Menendez, such as going into a closed room, immediately after a confrontation in which Lyle Menendez was saying to the father in the presence of the mother, you're not going to touch my brother anymore, indicating that he was in fact going to carry through on his threat to reveal to the world that Jose Menendez was committing this sexual abuse. At that point in time, given the entire history and the threats up to that point, his turning and saying, come on, kitty, and going behind closed doors, I think distinguishes it from a situation such as you had in Aris, and certainly is not a situation where the court can say on those facts, I have no doubt as to the insufficiency of the evidence. That series of confrontations and that history of threats gives can give me no doubt that there is insufficient evidence here to justify a reasonable self-defense instruction. And that's the
definition of imminent danger.
and I think that's under the ARIS definition of imminent danger. That's not trying to incorporate subjective elements into it other than the antecedent threats. And that's staying strictly within the definition of ARIS of imminence, and also taking into account the point that Ms. Abramson made before, that it is imminence is also defined in the Calgic instructions. This is 5.30. The last sentence says, necessary to prevent the injury which appears to be imminent.
Exactly.
So appears to be imminent is a slightly more flexible standard than actual presence of imminent. It is.
There doesn't have to be actual danger, and that's the law. But whether it's actual or apparent, it has to be reasonable for the perfect self-defense. The belief has to be reasonable.
I understand. My only point is the standard as incorporated in the jury instruction is appears to be imminent. That is, and the ARIS definition can be incorporated into that, appears to be about to happen. It's not, is it about to happen? It appears to be about to happen. And in light of the entire history of that week, taken in the context of the history of the antecedent threats that are revealed in this record, it at the very least would appear to a reasonable person faced with these circumstances would appear to be imminent, or at least the jury could so find.
May I add something also, Your Honor? Just in terms of prior threats, I think that the court cannot view these last few days in a vacuum, and I think that there is a history of both verbal threats and threatening behavior by the parents throughout the life of the children as they grow up. Certainly, there's been testimony that Lyle was threatened by his father during the periods of his abuse, that Eric received similar threats from his father during his own abuse. We have Lyle talking to his father at 13 about Eric's abuse and receiving threatening warnings then about the secret getting out. Mr. Burt referred to the incident with Brad Werner, who was the tennis coach, in which Jose Menendez hit Lyle in the face.
Yes, I remember that.
That was Brad Werner, not Robbie Klaus. And said,
Yes.
if you ever embarrass me again, I'll kill you. We have the incident with Craig Signorelli in front of a number of people in which Jose Menendez threatens to kill him if he doesn't stay away from his family. We have the separate incident with Robbie Klaus, in which the father threatens him. Robbie Klaus, then a 35-year-old man, threatens him with regard to putting any ideas in Lyle's head about turning pro. And Robbie Klaus is frightened enough that he stops coaching him and passes on the message to Lyle Menendez. And during the last week, in addition to everything that Lyle Menendez has witnessed throughout his life in terms of his father's fearlessness and him bragging about his interaction with business associates, watching how he behaves around friends and relatives, there's these series of statements which are very threatening. In addition, they have the history of the mother's rages and her threats to poison the family. So there is a lifetime of threatening behavior in which these last few weeks occur. And I think it's impossible to separate out the two in terms of someone's perception of reasonableness. And there's something else I'd like to call to the court's attention. Whether it appears totally reasonable or unreasonable to this court that they would have believed that they were going to be killed. As the court knows, we all get hundreds of letters, and there are hundreds of people out there who've watched this who say there's no doubt in their mind that Kitty and Jose would have killed their children. Now, whether they're right or wrong, they are certainly, people out there in the public who see things differently than this court does. And
Well, bear in mind that the law of self-defense and how it's developed and the restrictions on its use have a very substantial foundation in our law that one person doesn't have the right to take the life of another. Your focus in defending people accused of crimes is always on the defense as to the defendants and their rights. But the law is that everybody has a right to live, and there has to be substantial reason before any person's right to live can be denied. And that's why there are limits on the law of self-defense. So what some emotional reaction might be to evidence that's been presented and how people react to it based on their own personal lives or background or whatever is not the point. The point is there has to be some objective standard in order for the law to be applied in self-defense.
I understand that, but my point with regard to the letters are that there are a great number of people who believe that Kitty and Jose Menendez would not have let the secret out, who believe they would have killed. And so it's not a question of whether they know the fine points of the law or not. It is their reaction to the factual material that's presented that they were going to kill. Now, clearly,
I think you could focus on something more substantial than counting letters. It really is not helpful to me.
It is helpful in that we are suggesting, or I am suggesting, that other people may see it differently than the court, and we only want the opportunity to have this issue judged by the jury.
I understand that. That's what we're discussing. That's the issue that the court is addressing, permitting counsel to present your views as to whether there has been substantial evidence presented that would justify instructions on this area of law. And we're familiar with the rules that apply in that regard. There's various cases that talk about the standard of evidence that must be produced or in the record for instructions to be given on the law. And if and when we get to a completion of this discussion, I will recite what that standard is. Yes.
Oh, I was going to say, Your Honor, that I agree with the court with respect to the notion that there is obviously a very strong societal policy in effect that underlies the law of self-defense in this state, in every state. But there is also an awareness of, most of our rules about self-defense in the state were written in the 19th century and were written for envisioning a situation basically where you have adult males in conflict with each other, and were written with the notion that the requirement of imminence was to make sure that trigger happy gunslingers, basically, or fellows engaged in barroom brawls, did not take lives of other people without every reason to believe, and I think that's where the word reason comes from, but every reason to believe that that's what was necessary to stop a lethal assault. And when you're dealing stranger on stranger, you really can't know whether a person is really going to harm you except by examining their actions. And I think the concept of imminence was introduced, or was a notion, in order to prevent people acting sooner than the intention of their adversary by action could be known. Now, that's fine in stranger on stranger conflicts, but I think it is not an adequate response to say that the law of self-defense in this state then only works for people in those kinds of conflicts, and we will leave for other groups and classes of people than adult male strangers manslaughter with 19 years in prison rather than justifiable homicide. I think the point is that Flanell apart, the law has to gain recognition and has gained recognition, first under the series of cases dealing with antecedent threats, and then by the introduction of the notion that's encompassed in 1107, that there has to be a greater understanding that when the adversaries are basically unequal, and when the history between them is more than you could ever explain in stranger to stranger confrontations, then you cannot say that people behaving in the context of a lifetime history are per se unreasonable if they act before
1107 of the Evidence Code
gunslinger
doesn't
would
say that. 1107 of the Evidence Code just says that this evidence may be received. Doesn't say how it should
I
be
understand
used,
that.
or it doesn't say, and it certainly doesn't create, this
understand
whole
that,
area of
Phil.
law of battered women and battered children
I understand
does
that.
not create any legal defense.
But it does recognize that there are psychological realities that exist between people who know each other that are far more complicated than those between strangers. Or, I mean, that's the fundamental notion behind 1107. And the problem is that the only way that courts apply self-defense is to deal with the stranger on stranger, adult male, everybody's even situations, then a vast number of people are being discriminated against by this law for no sound policy reason.
No, but the other side of the question is, again, how does one deal with the subjective element that is introduced by expert testimony regarding battered women or battered children? You then set up a different class of people who have greater rights than others because of their subjective beliefs.
They wouldn't have greater rights, Your Honor, if you, now, and I'm not arguing for this in this case because I don't really think it's necessary in this case. I think there is enough antecedent threat evidence in this case and enough behavior on the part of both the defendants and the victims in this case to justify a reasonable self-defense. But to answer your question, there is a reasonable battered person standard as well. The notion that you can't write your own rule for yourself as a unique individual and say, I was acting in good faith, therefore I'm reasonable, is one that no one is quarreling with here. But it doesn't create greater rights for battered people if they act reasonably within the context of what has happened to them and are acting the same as all other battered people would act under the same circumstances.
Well, but the
That doesn't give
circumstances
them
of each
greater
case
rights.
is different because you, in essence, have, as you presented here, the life history of each defendant. And what you propose, or at least Mr. Burt proposes, is for the jury to put themselves, or each individual juror put him or herself in a position of having experienced everything that these defendants experienced in their entire lives.
Let me give the court an example, just to distinguish that we are not arguing for a subjective, but rather an objective standard. And here is the difference. As you heard in this trial, whether it's believed or not, but there is a great deal of research now in the notion that children can be grievously harmed by psychological abuse. And let us assume we have a family in which the only form of abuse was psychological abuse, and there was never a threat to kill for any reason in that family. And yet you wind up with children who have many of the perceptions, many of the perceptual anomalies, if that's what they are, and the hypervigilance and the hyperattentiveness of other battered children. Okay, well, there has been no history of lethal threat in my hypothetical family. Okay, I think then if a child of that hypothetical family were to claim a fear of death at the hands of those parents, there has to be an analysis of what was the antecedent behavior in that family. And a court could say it is absolutely unreasonable for this child to have believed he was threatened with death based on this behavior of these parents, because there never was any lethality to the behavior of those parents or any violence. So I don't think that just because in other words, we're not asking that all abused people can write their own standards. All we're saying here is that this is a case with simply a long-term history of antecedent threats of one type or another, but threats of bodily harm or death or rape or other justifiable, other actions in which it is justifiable to prevent them with the use of lethal force. And I think that's all we're asking, is that this jury be given the opportunity to weigh whether, given that history of lethal threats, these defendants acted reasonably in believing that harm was imminent. I don't think there's a dispute here, in fact, as to whether or not they were reasonable in perceiving they were going to die. I think the only dispute is whether they were going to die then. And for that, in other words, whether...
Are you saying that the prosecution doesn't dispute your theory?
Oh, no, they dispute it, but I think in
You said there's no reasonable dispute.
I haven't heard the court being concerned about whether or not their perception of potential death.
Well, I'm not weighing the evidence. I'm just evaluating whether there is sufficient evidence to give these instructions to the jury. It's not for me to
No, I understand, but it seems that what we're
evaluate the credibility of witnesses here.
No, I understand that. But I think what we're talking about here is whether or not, as a matter of law, this court could say there's no evidence to support the notion of imminence, not that there's no evidence to support what the harm that was perceived would be. I don't think the court has even suggested that there is no evidence in the record that the harm that they were afraid of was the harm of death. I think the issue that keeps coming up is whether it was imminent. And I think the problem is, if the cases that deal with male-male antecedent threats or male-female pure antecedent threat evidence say, as they do, a defendant faced with an assailant where there is a history of threats and violence has a right to act more quickly than one who does not. And I think the policy behind that is because if you know the person and you know that they threaten you, you're not jumping to conclusions or misperceiving the situation because you have special knowledge. If there are those cases in California, and there are, I think it is very dangerous, if you will, for courts to start getting involved in drawing the line about how quickly is more quickly. And what does a closed door mean to the court versus what did a closed door mean to these defendants, or what would the closed door mean to the jurors? I think it is even possible that there can be a case of a sleeping victim where Aris would not apply. And so if being asleep is not enough to say in all cases a sleeping victim, it could not be imminent with a sleeping victim. And I'll give you my example. I think it's much, you cannot say in all cases, because the potential victims who are awake and alive and behind closed doors are behind those closed doors, that the threat of death could never be imminent. And I think that's what it boils down to. I mean, you can envision a victim who is asleep but rigged it up in such a way that the second he flutters, the gun's going to go off and blow away
I
wifey.
could use my imagination to come up with all sorts
Yes,
of
I'm sure
theories.
you could.
All right,
Could I-
yes, very brief.
Yes, the court had asked how the defense proposes to distinguish for the jury the difference between the objective and subjective standards. And I think that the cases cited to the court point the way in that regard, because
Okay, if you have something specific in mind, you can put it in writing and present it to me when we resume.
well,
As far as an instruction, if you have such.
it's just a general statement as to,
Well, if this is something that you intend to pursue as part of your presentation to the court and or the jury, then if it's something that is going to be to the jury, then it would have to be by way of instruction.
no, I understand. And
So-
it's an instruction that's already before the court. That's why I wanted to
Oh,
point it
okay.
out. The Torres Pena line of cases indicate that the court, on request, in a case of perfect self-defense, should instruct on the antecedent threat issue.
Right.
And those instructions have been proposed by the defense. The prosecution has submitted an instruction based on Aris, which seeks to limit the expert testimony to the question of subjective reasonableness and, subjective belief. And Aris says that in a case where the court gives perfect self-defense instructions, that a limiting instruction should be given, indicating that expert testimony is relevant only to prove the honest belief requirement for both perfect and imperfect self-defense, not to prove the reasonableness requirement of perfect self-defense. So I think in combination, the prosecution's request and the defense request do serve to outline for the jury what is and is not a permissible use of that testimony.
All right. Any other brief remarks?
Yes, I have a brief remark.
Yes.
In this case, there is no history of life-threatening violence against these defendants. They were never taken to the hospital, having been beaten to within an inch of their life. And if Mr. and Mrs. Menendez had been engaged in any conduct which a reasonable person could construe as life-threatening prior to their murders, then I think the defense would have an argument that self-defense should be given. But given those two failures in this case, there is not substantial evidence to support the giving of self-defense instructions.
All right. We'll resume at 1:45. Other than going back to our discussion regarding jury instructions, do counsel have any other matters you wanted to bring to my attention?
You want to deal with the photographs later on? I'm marking some additional ones.
I have an exhibit I'm not objecting to anymore.
All right. If you're still doing photographs and stuff, let's go back to the instructions.
Okay.
Okay. Anything further from anybody on the subject of the self-defense?
The court had mentioned the possibility before the lunch break of submitting additional jury instructions that would clarify the distinction between the subjective and objective standards. And reviewing the instructions that are already before the court, we think that if the court gave at least one version of the antecedent threat instruction, which one or both parties have proposed, and in addition gave people's special instruction number 1, that would be the appropriate way to handle the distinction. And that is the way that the Aris court outlined as being the appropriate response in a case where the court gives a perfect self-defense instruction.
All right, anything else then on the subject of self-defense as to whether it should be given in this case?
No, Your Honor.
All right, this is clearly a matter of significance to the parties. It was the subject of early discussions in this case. The court solicited from counsel prior to commencement of jury selection your views on the subject, and within the last week or so, the court did receive a response to that solicitation. And the court has reviewed the evidence and reviewed the case authority on the subject. The issue before this court is whether certain instructions should be given at the request of the defense. The law in California recognizes, in the context of homicide anyway, two types of self-defense. One is the so-called imperfect self-defense, which we have discussed this morning. And the other is perfect self-defense, which we have also discussed this morning and afternoon. Imperfect self-defense is an area that is been the product of judicial creation in California. And the case that has been referred to by counsel, variously pronounced as Flannel or Flannel, People versus Flannel, 25 Cal 3rd 668 is the California case that deals with this subject, and announced the view of the California Supreme Court in 1979. There had been some earlier discussions in the appellate courts relating to imperfect self-defense. But until 1979, that had not been firmly established as the law in the state of California. It's my understanding that that concept, imperfect self-defense, to some extent anyway, is being reviewed by the California Supreme Court. However, the law of the state is as announced in People versus Flannel until it's changed, if it is changed at all. Self-defense, whether perfect or imperfect, requires that the defendant's acts or actions causing the victim's death were motivated by an actual belief or perception that the defendant was in imminent danger of death or great bodily harm from an unlawful attack or threat by the victim, and the defendant's actions were necessary to prevent the injury. And for the perfect self-defense, there's an additional element that a reasonable person in the same circumstances would have had the same perception and have acted in the same way as the defendant. If there is a finding of imperfect self-defense by the trier of fact, that negates the element of malice aforethought and reduces an unlawful killing to manslaughter. If a trier of fact finds that perfect self-defense has been established, then a defendant is to be acquitted of the charged crime. The issue before this court is whether or not this court should instruct the jury on perfect self-defense. The people have conceded that there will be, or both sides have agreed that there will be imperfect self-defense, as I've outlined. The law in the state of California is that the trial court should instruct the jury on every theory of the case put forward by the defense, but only to the extent each theory is supported by substantial evidence. That's the language in People versus Flannel. Substantial evidence is defined as evidence which is sufficient to deserve consideration by the jury. That is, evidence from which a jury composed of reasonable men could have concluded that the particular facts underlying the instruction did exist. And the court has reviewed the evidence presented. I've reviewed it quite extensively, both as it was presented and as it's been presented to me in this phase of the trial during discussions of jury instructions. And the issue is whether there has been sufficient evidence to justify this self-defense instruction, the perfect self-defense instruction. Having reviewed the entirety of the evidence in this case and recognizing it's not for the trial court to determine the credibility of witnesses or to evaluate the strength of the evidence, but just to make the threshold decision as to whether there has been sufficient evidence put before the jury to justify an instruction on this concept of self-defense, perfect self-defense. It's my view, after reviewing the entirety of the matter, that there simply is no evidence of the objective standard of reasonable belief in the imminent danger of death or great bodily injury or the attempt to commit an atrocious felony to justify giving the perfect self-defense instruction in this case. The defendants, by their own testimony, had other means to deal with the distant threat that they say they perceived. They could have done other things. They could have left. In fact, they did leave the house. The argument regarding retreat and the law that, and the rule of law that a person who has the right to exercise self-defense need not retreat only exists if the person has the right to exercise self-defense. In this case, there was no objective, reasonable belief that would justify exercise of the right of self-defense. The bulk of the evidence presented to the jury during the course of this trial related to the subjective belief of the defendants, what they actually perceived, which is an element of imperfect self-defense as it is of perfect self-defense. But it did not relate to the objective standard that is a requirement of perfect self-defense. And I don't find that there has been any substantial evidence, any evidence justifying the jury being instructed on perfect self-defense. Therefore, the request to so instruct is denied. And we'll now proceed with further discussions regarding instructions. Are you ready to proceed?
Yeah, sure.
Okay,
Did the court have the list that we were working off?
I do.
The last time?
Yeah.
The
Let me say, I don't know how you want to proceed with the Eric Menendez portion of the instructions as to the details of the specific instructions. If you want to do that separately, we can. Or if you want to participate in that, you can do that. We've already dealt with the a good deal of the instructions with the Lyle Menendez case.
Who's already gone?
Yeah, I think Mr. Kuriyama and I agree that so rather than jump into the middle of these discussions, we'd be better off just doing ours from scratch on through.
Okay, if you want to do it tomorrow,
How can we do it? Well, what else is happening?
what I'll do is do it tomorrow, and we'll have, well, let me first see, if depending on time estimates here. What is your time estimate for argument?
When to start or how long?
How
it
long?
lasts?
How long?
Mr. Burt and I are planning on together being about a day.
Okay, and the people?
It's still my plan to do a morning session for opening and a half day for opening, a half day for closing. So as long as we start, at a reasonable time,
So we start Wednesday, we should be through probably by Thursday.
well, no, if we do Wednesday morning, yeah, that's true with argument and then instruction.
Okay.
How long do you think instruction will be?
In a case with
An hour and a half?
things that we have here, it could be up to 2 hours, might be a break in the middle.
All right, then we have a cushion of a half a day then to get us to Friday afternoon.
All right, is that then agreeable that the argument for the Lyle Menendez case would be Wednesday morning and that we would do instructions as to Eric Menendez tomorrow?
That's fine.
It actually might shorten the discussion on instructions if we were to have the benefit of the court's rulings
Yes.
on the Lyle Menendez instructions, and we wouldn't have that.
Well, you would at least, you would know what basic rulings would be.
You could see off their transcript.
We could read the transcript, but we wouldn't have the transcript until.
No one.
Well, but I would know what the rulings have been, so. As far as the arguments and things of that sort, you might have different views on certain things. There are certain specific things that deal with one defendant that don't deal with it.
They're also, the instructions are different for
Yes.
each defendant.
There are certain differences,
Yeah.
yes.
So,
Okay.
where are we?
Well, it's up to you. If you want to sit here now and you could listen to what's going on, that's fine.
And the other thing too is that, we need to resolve this, the data of the photographs.
If you want to keep going through that while we start on this, you're done? Okay. Well, if you want to do that first, then we can do that. I don't care. Do you want to do the exhibits and get that resolved, or?
Yes, well, here's the point. The court has made certain check marks and,
Yeah, those were not necessarily for the whole page, just for one or so.
Yes.
That's right.
and, well, sometimes it's designated what they wanted, and I don't know if you're approving of all of their numbers or
No,
just something.
actually, I wasn't.
Okay, so I sort of, yeah, but let's just do this. You want me to just come stand next to you so we can look at them together? I think the court needs to see them again, right?
Well, if you guys want to agree on those, it's fine.
Well, I'm not going to agree on any of them because I don't think that any of this process was appropriate. And the problem is, if the people are then allowed to select out certain photographs with no explanation by anybody because they think they show something, well, then we have the counter photographs that show something else.
That's fine. That's
And so
fine.
we wind up in the endless battle of the photographs.
Well, if you could just sit down together and work it out, we probably would be able to, even though you'll still have your objection, and I'm not going to,
Actually, I think the whole.
Mr. Kuriyama has invited me out into the hallway.
okay. well,
He said, in fact, let's step
need a
outside.
chaperone.
But I think it was benign.
The only difficulty, Your Honor, is I believe Mr. Kazanich wants to offer them against Lyle Menendez also, so.
But we'll show you what
We'll let them discuss it first, and then you can have your own separate.
we have to post.
I'm going to stay here.
You stay here and watch.
Let's go back to the instructions then of Lyle Menendez, so we can get you folks on your way.
Your Honor, does the court have the vertical list?
Yeah.
Could the court go through and indicate what the court's going to give?
I mean, what we've done so far?
Yes.
You don't have that down?
Well, I do, but I want to make sure that what I have is correct. If that, I mean, I believe that,
Okay, let's do that. so
Yeah.
that We're online here.
because a lot of them we've deferred to, I think, along the way.
Not too many of the
Okay.
ones that, on the first 2 pages,
Mhm.
we stopped when we got to self-defense. I think.
And then we kept going. Didn't we do some more after that?
All right, let's go through here then.
All right.
Those that are, both sides of requests I'm not going to talk about. 1.25 is rejected.
Correct.
I'm giving the unmodified 2.03 and the unmodified 2.04, the unmodified 2.05. 2.06 was going to be modified to delete the word offer to compensate a witness, as I recall.
And then,
It's a deletion.
That's what I have.
Place.
now the defense has submitted a new 210.
Well, let me see if I have all of,
It was filed December 3rd.
okay. All right, I had previously, I don't know if I ruled on it. It was,
I think the court indicated that it was going to be given, but medical needed to be changed. That's the notation I have.
well, the issue was the consistence, the modified, or the defendant's modification, I guess, is what we were hung up on. And I had inquired what the theory of the defense was for that, as to why it would be admissible if the motive to fabricate pre-existed the statements. Wasn't that our conversation?
That was a conversation. I think I had indicated to the court that the theory is that the people have not pinpointed a theory of fabrication. Their theory of fabrication, it spans the breadth of the case from the very beginning. And so any evidence of a consistent statement which contradicts their theory of fabrication, it seems, would come in as a prior consistent statement.
All right, what is the people's response?
Well, Your Honor, the reason that this was pulled is so that the court could instruct the jurors that the statements made to the psychological experts.
Right.
And the modification offered by the defense is that prior consistent statements may be considered in this context. And the court's already going to give the instruction about prior consistent and inconsistent statements, so we would object to that modification. Moreover, the medical expert is really not applicable, and I think we were going to change it from medical expert because these people are not medical doctors as to this defendant. They were all doctors of philosophy. So I think it should be stated testimony of a psychological expert. And it's just to caution the jury about those kinds of statements and the limited purpose for which they're admitted.
One additional thing, Your Honor, on the theory of recent fabrication, that there's clearly before the jury the inference that one or both defendants fabricated their trial testimony as opposed to fabricated at some point in the past. And I think any prior consistent statement prior to the time of trial comes within the exception for prior inconsistent statement, and the case that says that is People versus Ainsworth.
The way the evidence was introduced was ultimately that the experts were vouching for the credibility of the defendants and their statements. Ultimately, when cross-examined, the people attacked the credibility of the experts and asked ultimately whether or not the expert believed the defendant, which was part of the testimony offered here. only inquiry I have is whether or not the limitation of section 210 then, or Calgic 210, limits the breadth of that testimony. Or the scope of that testimony.
Well, yes, because the jury may not believe, but the statements that were made to the expert.
Okay, we had discussed this before, and as to when the fabrication or motive to fabricate occurred, and the court is inclined to give just the straight 210 without the modification. So the defendant's version is rejected.
But is it going to say medical expert?
Well, did you have any other idea?
It should be psychological expert.
That would be fine.
All right.
Want to modify it? Any objection to that modification? I know you object to the instruction itself, and that's understood.
Again, Burgess is classified as a medical expert.
She didn't testify to any statements made by Lyle Menendez that I recall in front of his jury. To her. The only statement she testified about was the December 11th tape, and those weren't statements made to her.
How about just expert?
That's fine too.
All right, that's probably the easiest way. If we can expedite things, it would help too.
Okay.
All right, the next disputed instruction was 2.20, and the issue held in abeyance was related to Oziel and Smith. As I recall, misdemeanor conduct.
Correct.
Now, the Supreme Court, in its wisdom, has created a substantial difficulty for the trial court in dealing with this sort of evidence, because if it's really introduced as evidence of a misdemeanor described as conduct rather than as a conviction, then there's a requirement of defining what the misdemeanor is and everything else. It seems to me that if it's just referred to as past conduct of the witness, that should be sufficient. Why does it have to be characterized as criminal conduct or as a misdemeanor?
How about past criminal conduct of a witness?
That's fine with me. I don't know why we need to refer to it as misdemeanor. Some of this stuff apparently could have been a felony. If
I agree. And in fact, the evidence before the court as to Oziel is a felony. The charge that the people were going to prosecute him for was, I believe, Penal Code Section 134,
Right.
which is submitting false documents to a court. That's a felony. So I agree with the court. I think it should be modified to take out amounting to a misdemeanor.
all right, is that agreeable?
That's fine.
Okay, then 2.20 would be modified to remove misdemeanor. As far as 2.23.1 then, what did you want to do with that?
Same modification. It would, the name of the witness would be inserted and we would strike out amounting to a misdemeanor. So the first sentence would read, evidence has been introduced for the purpose of showing that a witness, Dr. Jerome Oziel, engaged in past criminal conduct.
It needs to be stricken twice then.
Correct.
All right, any objection to that modification?
That's fine.
All right, then 2.24, the court indicated it would give the standard instruction, but modify it to insert the words or their opposites.
And would the court strike out the second paragraph of that instruction?
2.24.
Because I don't think it applies.
Yeah, there hasn't been any evidence about that. right? And then 2.40 and 2.42.
Those are withdrawn.
The defense has submitted an instruction.
I actually think it's the people's burden to submit an instruction to limit this, but we've submitted one for the court, which hopefully limits it to the purpose for which it was offered. But if not, I think it's the people's burden.
Well, here it is.
Well, the people had submitted one. I don't think it was modified, though.
No, we submitted one.
Was yours modified to insert the purposes for which it was offered?
No, I just offered the standard one because we hadn't yet, I don't think the Calabasas burglaries were in
Yeah.
yet.
Okay, as to the defendant, Lyle Menendez, then 2.50 was offered by the prosecution. And I don't have it in front of me.
Do you have the new one that the defense has offered?
Yeah, I have that. Go ahead.
I was going to say we object to that because, as I recall, the only evidence before the jury on the burglary came in to test the credibility of Dr. Conti's testimony concerning the 12/11 tape, and it was never offered on the issue of motive.
That's right. It was not offered for any purpose other than to challenge certain opinions he expressed.
I believe it's also mentioned in the December 11th tape.
Well, we certainly didn't offer it for that purpose in offering the December 11th tape.
The use notes indicate that the trial court is not required to instruct sua sponte on
No, it's really,
so
it's a type of instruction that points in a certain direction. So,
Actually, I think on this evidence, the more appropriate instruction would be a modified version of 2.42, which deals with character evidence, but
well, if you're not asking for 2.50, I'm not going to force it on the defense.
and that's fine with the prosecution.
then we're certainly not asking for our version of 2.50 to be given.
Okay.
So 2.50 will not be given.
All right. The defense version is withdrawn and it will not be given since the defense objects to the people's version. .52 was rejected.
Right now, Your Honor.
2.62 was rejected.
Your Honor, I wanted to ask the court about this. In light of the December 11th tape and the defendant's failure to explain it, I would ask that 2.62 be given.
Well, your theory is that they were required to get back on a witness stand and explain it?
No, not that they were required to do it, but once you take the witness stand, you've waived your Fifth Amendment privilege not to testify.
Right.
It's the people's position that in light of their testimony, their waiver was not limited to any particular topic, that their waiver was complete. They testified to matters within their knowledge between age 2 and 21. And it's the people's position that having waived their Fifth Amendment privilege and failing to explain or deny that tape, that this instruction should be properly given.
The problem with that is we did explain or deny it through the testimony of the expert witnesses.
Yeah, I'm not going to give that instruction.
All right. But that leads me to another question. Can the people comment in argument on the defendant's personal failure, not the expert's failure, the defendant's failure to explain the December 11th tape?
What's the defense position?
We would object to that as an improper comment on privilege against self-incrimination.
All right. What I would suggest is that if this is a major issue for the prosecution, you can research it and see if there's any case law dealing with such a comment. I really haven't given it any
Well, I
thought.
was thinking in terms of the brief that I filed months and months ago dealing with whether the prosecution can recall a defendant. Does the court recall that I filed that?
I do.
All right. And my argument is that insofar as the defendant has no Fifth Amendment right once he's testified, that commenting on this is not Griffin error. And that's what I'm concerned about.
Well, I understand your argument, but if you have a case that says that, that would help.
All right. Otherwise, I should refrain from mentioning it.
It would seem to me that you should do so unless you want to discuss it again before you.
All right. Well, I'm not sure I'll have time between now and then to find such a case.
All right. I haven't given it any thought, so it's a type of comment that I would want to have some.
Right now, as a 2.70, I have a notation on my list that I don't quite understand.
Yeah.
Um,
All right. 2.70. Something to do with tape recordings and exculpatory tape recordings
I've submitted,
versus inculpatory tape.
I submitted to the court a modified 2.70, which deals with the exculpatory aspect that we discussed the last time. And I think the people were concerned that the instruction somehow improperly implied that a tape recorded statement was an oral admission, and they were going to propose some modification.
Now, your 2.70 is a complete reworking of,
No, the only change is the addition, the last paragraph.
everything else is identical.
Correct.
Well, again, it doesn't take into account any tape recorded statements made by the defendant. Any out-of-court statement made by a defendant that was not tape recorded.
I was only dealing with the part that I was concerned with, and I think the people had their own proposal. I have no objection to adding anything that people want about tape recording.
I think that evidence of an oral confession or admission of the defendant should be viewed with caution unless it was tape recorded.
Well, the way he's got it here, Mr. Burt has put one sentence in, and then you're going to have another one. If you can blend them together in some way, it might help.
Are you talking about the newest version,
Yeah.
December 3rd? Are you talking about the last two sentences put together, or?
Yeah. What you're proposing, evidence of an oral confession or oral admission of the defendant that was not tape recorded should be viewed with caution.
Yes,
That's what you're suggesting.
yes.
And then leave the last sentence as he's got it.
No, I actually don't think that should be given, the last sentence. First of all, it's a double negative. It's difficult to understand. And secondly, I don't think that's, I think that this sentence before limits,
Yeah. What you're saying, the sentence evidence of an oral confession or admission defines what is the subject of caution. Everything else would not be subject to such caution.
correct.
Problem I have with the language proposed by the people, not tape recorded, it implies that if there's a tape recording of a statement, the jury does not have to view it with caution. And in the circumstances of this case, where you have a tape recording which begins and ends midstream and is part of a larger discussion which includes oral statements or oral confessions, I think it could be subject to misinterpretation by the jury that somehow that tape recording should not be scrutinized with any degree of care simply because it's on a tape recorder. And I would agree that if you had a tape recorded statement that incorporated the entire conversation between the parties, that would be a situation where some sort of cautionary instruction would be applicable, but not in the circumstances of this case, given the fact that the larger part of the tape recorded statement of December 11th was not recorded.
But only the portion that was recorded is before the jury. The rest of it is not. So the jury doesn't have anything else but that tape recorded portion.
Well, and I guess the second problem with that is you have testimony in the record by Lyle Menendez that that was a false statement by him, or that there were certain portions of that statement that are false. So the fact that it's tape recorded obscures that second issue, which a jury has to decide in this case. That is, was it properly recorded? Yes, because it's on a tape recorder. But second of all, is that a true statement? And to tell a jury that they shouldn't view a tape recorded statement with caution in the circumstances of this case allows them to gloss over that second issue.
Well, the whole purpose of that instruction, or that portion of the instruction, is just to caution the jury that one, I suppose, an entire oral statement could be fabricated when it's recounted by someone else if it's not tape recorded. And number two, recollections can be faulty as far as the details of what was said. But when you have a tape recording, it's there. It's not fabricated per se, and that someone is not making it up. It's there. It's just a question of how the jury evaluates it, is what you're talking about. The content is there for the jury to listen to, and there's no dispute about what was said. It's just things surrounding it that are your concern.
Well, what we're concerned with is the omission of the larger part of that conversation. And since what's being talked about there are motivations and themes, the tape itself could represent a half-truth in the sense that it doesn't present the whole picture of what was discussed. And that was the thrust, I think, of the testimony by the defense. And yet an instruction which says if it's on the tape recorder, you don't need to view it with caution seems to contradict that theory.
Well, another way is for the defense to request that there be no cautionary instruction whatsoever, and then you don't have it going either way. Just remove that. It's required to be given sua sponte by the court. If you're concerned about the particular facets of this case, you can request that we not give anything one way or the other.
Problem is then we're left without any instruction on October 31st or December or November 2nd. And there are other statements in the record, Glenn Stevens statements.
That's true.
Marzi Eisenberg, all across the case. So,
well, the only way to deal with this is say the evidence of a non-tape recorded confession or admission of the defendant should be viewed with caution. I'll see how else to do it. Otherwise, you're saying that the statements the defendants made after the offense to the police should be viewed with caution. And they're tape recorded. There's no misinterpreting what the words were, just external evidence as to what was meant.
right, that's a good example of where it would apply if the people were offering that as a confession or an admission. They're not. They're being offered for the non-hearsay purpose of showing they made false statements. That's not an admission or confession.
Well,
But I think that
So there's some admissions
in that situation, that would apply. But I have trouble applying it to a situation where you have a partial tape recording and the defense is contending that that partial tape recording does not present the entire statement accurately.
Well, what is the people's position in regards to perhaps isolating the December 11th tape and treating it separately, or?
no, Your Honor, because as the court pointed out, there are other tape recorded statements of the defendants, which should be exempted from this cautionary instruction as well. It seems to me that given the nature of this particular case, that the defense would probably be better off if it's not given at all. This last paragraph that's usually bracketed.
I think the court should leave it as it is in Calgic, and then the parties are free to argue that under that instruction, the prosecution can say, well, you don't have an oral confession here because it's on tape. And the defense is then free to stand up and say, yes, but that's not necessarily true because you've only got a partial tape. That still would be allowed within the language proposed by Calgic, and we don't get into this problem of having an instruction which seems to favor one side over the other.
Well, certainly that's not the purpose of the instruction. Let me do this. We're getting bogged down on something that really shouldn't take all this time. I'll look at the one case cited in the use note, People versus Hines, which deals with the subject we're now discussing. And I'll let you know tomorrow, if not by the end of the day today, how we're dealing with it so that it's resolved. I'll just prepare something that'll deal with it. All right, the next instruction, the court was going to give 2.90 as in Calgic.
And the court has that new case that's People versus Jaramillo.
You gave me a case a while back. The law is the same as when we discussed it before. It's up for review for the United States Supreme Court. It's anyone's guess what they'll do and when they'll do it.
Your Honor, did the court already decide not to give her 3.0 and 3.01?
You withdrew it,
Defense withdrew it.
or the defense withdrew it.
Okay.
And the court's going to give 3.31 and 3.31.5, 4.30, 4.31, 4.35, and 4.43 were all refused. 4.71 is going to be given. 4.71.5 is refused. And that took us to the self-defense instructions. And in light of the court's ruling, are there any of these instructions that the defense would be requesting other than the imperfect self-defense 5.17?
The defense would ask the court to give 5.13 in a modified version, which would state the principle that a honest but unreasonable belief in the necessity to prevent a forcible and atrocious crime would reduce the crime to manslaughter.
And what forcible or atrocious crime would that be?
That would be forcible sodomy, assault with a deadly weapon, assault by means of force likely to produce great bodily injury.
Well, those latter two are really encompassed by the self-defense instruction, or the flannel instruction 5.17. Imminent peril to life or great bodily injury. And as far as a sodomy is concerned, who is it that was going to be sodomized?
Eric Menendez.
And is there a case law that supports that proposition that flannel would apply to forcible or atrocious crime on another?
No, and we're relying on flannel itself. It seems that the theory of mitigation there is an honest but unreasonable belief in the necessity to defend reduces it to manslaughter. So why shouldn't a similar theory of justification or excuse, which is honest but unreasonable, they're really the same principles of law, only applying to different circumstances?
Well, 197.3 or subsection 3, which is the perfect self-defense in relationship to atrocious crimes or commission of felonies, defines the relationship of the individuals, and brothers are not included in that relationship, if one want to be technical about it. It's language in the statute, but you're going beyond 197.3.
Yes. And I think that the proposal could be,
I think there was one submitted by Ms. Morrissey along those lines. I don't know if you've seen it.
yes, and we would ask for it in that form.
Right, have people seen that?
Well, I'm sure I've seen it, but I don't, which special instruction
It's
is it?
one of those submitted, I believe, Friday or today. I'm not sure which.
All right, let me see if I can find it.
It's similar to what Mr. Burke read.
Is it the second set of additional instructions?
Let's- Um,
Yes, it was in the second set, I believe.
3 through 13?
Yes.
Okay.
I don't see it.
I don't either.
Well, if you find it, we can come back to it. Anything else in these self-defense instructions that
In terms going back to 513, the proposal that Lyle Menendez would make, Your Honor, is that 517 be modified, which is the flannel instruction, so that it would read, a person who kills another person in the honest but reasonable belief in the necessity to prevent a forcible and atrocious crime, or in the necessity to defend against imminent peril to life or great bodily injury, kills unlawfully, but does not harbor malice aforethought and is not guilty of murder, and then the rest of it would be the same. So in other words, just incorporating the forcible and atrocious crime language into the flannel instruction.
and what is the people's position?
Yeah, that sounds fine. I would just ask that it be one of a string of 3 things. In other words, it would be peril to life or great bodily injury or to prevent a forcible or atrocious crime.
I think maybe a cleaner way to do it would be to submit a separate jury instruction, which would be exactly like 517, but would incorporate the forcible and atrocious crime language into that instruction. Otherwise, it gets too wordy.
You have a separate instruction for a forcible and atrocious crime?
Yes, but it would be worded exactly to 517. And I'll submit that to the court.
I would object to a separate instruction, Your Honor.
Well, I don't have a problem with a separate instruction. I'm not 100% convinced that that's the law, though, that there is a right to that instruction. Have you done any research to see if there was any case law?
I
on
have,
that?
and I've been unable to find any. So we're just relying on the principles in flannel.
All right. I don't have a problem with it being a separate instruction, but I'm not convinced that it's the law. And then you would need a separate instruction on defining a forcible or atrocious felony, unless you want to just include it in that instruction, 5.13. You can just, as you're modifying it.
Included in 5.13 or 5.17.
Whichever, you're making it into a a separate instruction. You want to just include a definition of the crime that you're referring to in the separate instruction dealing with it.
That's what I would propose to do.
Okay. Well, you submit it, and hopefully by tomorrow I'll review the flannel case and think about whether or not there is legal grounds for that. And I'm sure we'll have the same discussion with Ms. Morrissey and Ms. Abramson.
So the court then would give 5.17 in its
5.17 as it exists, and
All right.
5.13 as you modify it to, or actually another 5.17 to incorporate the thrust of 5.13 in regards to the forcible and atrocious felony. And then I'll review it to determine whether it's covered by the final analysis. So if you want to just submit it to the court, you can fax it to me, and tomorrow or in the morning if you care.
fine.
All right, any others?
Would ask the court to give 5.50 and in the second sentence substitute in place of the words right of self-defense, right of imperfect self-defense.
Well, they're not really being given that phrase imperfect self-defense, so it's kind of hard to use that. And the law only applies to if there's a right to self-defense, not imperfect self-defense. So I don't think this is the law. I don't think that would be a proper statement of what the law is.
I think that the imperfect self-defense doctrine goes to the absence of a reasonable belief in
Right.
imminent fear, but it does not touch the principle stated here, which is the retreat principle.
Well, but if you don't have the right to self-defense, you don't have the right to, the element of no retreat doesn't apply. And
Except on the issue of good faith belief, the jury may think that someone who does not retreat could not possibly have a good faith belief in the necessity to defend against attack. And this principle, I think, applies equally to both imperfect and perfect self-defense. And I think that
there are certain instructions that Eris talks about. I don't,
right.
I don't recall it referring to this specifically.
Eris deals with the antecedent threat instruction in the context of unreasonable self-defense and indicates that those instructions were given and were properly given.
Right.
And I think this goes to the same issue. That is, the issue of retreat does bear on subjective good faith in the necessity to defend, because a jury could easily say if someone didn't retreat, how could they possibly believe that the attack was imminent? And there's nothing in this principle that does not on its face apply to imperfect self-defense.
Your Honor, page 1193 of Eris discusses Calgic 5.50 in the second paragraph at the end.
Right, that was a former version of Calgic, which was framed in terms of a person being assaulted as opposed to a person being threatened. And here the court is saying the instruction in its former version was properly refused because it wasn't supported by any evidence of an assault as opposed to a threat. Well, they modified 5.50 now so that it reads a person threatened with an attack. So that objection doesn't otherwise apply to 5.50, and yet I think the court is indicating here that 5.50 would be applicable if it was phrased in terms of a person threatened with an attack. And that's exactly the form that 5.50 is in at the present time.
Well, except that 5.50 says a person threatened with an attack that justifies the exercise of the right of self-defense.
So just change it to imperfect self-defense.
Well, but that doesn't mean anything to the jury when you use that phrase, number
Well,
one.
it could mean something to the jury if the court were to, and in fact, I intended in closing argument to, in order for the jury to understand the issue of imperfect self-defense, to contrast it with perfect self-defense and to explain it in those terms. But I think the court could easily.
I mean, tonight.
I believe that 5.50 also talks about the reasonable person standard again.
Yes. It's a problem when you get into any of these instructions dealing with self-defense. They all have the reasonable person standard. The focus of the flannel imperfect self-defense is the state of mind of the individual. If that person believed in good faith or honestly or actually, however you want to phrase it, that he had to act as he did, then he's entitled to the jury's finding that there was no malice. So the focus is on the state of mind of the defendant, his subjective state of mind, not on the reasonable person standard that.
But Your Honor, if I could interject there,
Sure.
the concern is that the jury not assume that someone has to retreat before they can avail themselves of imperfect self-defense. So why can't we simply submit an instruction that says a person need not retreat from a feared confrontation, or whatever words you want to use, in order to avail himself of the rule that says if he has a good faith but unreasonable belief, blah, blah, blah. Just to let it, or put it at the bottom of the Flanell instruction to say a person need not retreat before they can avail themselves of this rule. That way we've just dealt with that concern, that they not think, well, they had options, they should have left, as if that were a requirement of law. And I think that's how you can deal with it, instead of trying to rephrase this in terms of the unreasonable person. All we really want to tell them is they don't have to flee in order to be found to have not been acting with malice when they had a good faith but unreasonable belief, etc.
What is the people's
It's
response
the
to that?
people's position that that is not the law. And by the same token, the people could request 5.52 and 5.53 and
That is true. You get into all
5.54
the disabled victim
and
and everything else.
5.55.
Going over to putting the extra bullet in Mrs. Menendez after she was disabled. How do you deal with that in the context of the instruction? Because if you get into one of them, you get into them all, and you really do have the whole extra self-defense instructions that are related only to the reasonable man and the standard it applies to a reasonable man.
And the point is that if you are faced with self-defense, you need not retreat. But if you're faced with unreasonable self-defense, the rule is not that you need not retreat.
Well, then obvious the people are going to argue there is a need to retreat, and that is not the law of Flanell. Because reasonably as you like, there's no burden on you to retreat, to take cognizance of your surroundings.
That's what I was saying. I don't know if it was before you came in or not, but the focus of flannel is on the state of mind, subjective state of mind of the defendant as to whether he actually believed what he
But
believed.
it's clear that people intend to get up there and argue they should have retreated, that they're not entitled to that rule of law because they should have retreated. And since in this state, even to kill and be found justifiable, you don't need to retreat. You certainly don't need to retreat in order to face conviction of manslaughter. You don't need to retreat when there's sufficient provocation, heat of passion either. People should not be allowed to get up there and argue that they should have retreated, that there's some requirement that they do that. And that's why I think we need some kind of comment on you don't need to retreat in order to avail yourself of that rule. But I believe it is the law.
All right. Well, as I said, and as we discussed, the problem is how do you then deal with all these other instructions that deal or relate to complete self-defense?
I think because we're not seeking complete, well, we were, but we can't seek complete self-defense, and since the issue isn't complete exoneration, that these other rules don't apply. Since the best that could happen here now is only manslaughter, I don't believe that these elaborate rules to make sure that if someone's going to walk out fully justified be followed do apply. But those are rules that cut against the defendant. In this case, since the people clearly intend to argue they should have retreated, which completely undermines Flanell, I think that's the only one of these instructions that should somehow be modified so that it applies, so that they can't make that argument, or else simply prohibit them from making that argument.
Did you intend to argue in that fashion?
That they should have retreated at the time, 5 minutes before they killed their parents. I mean, as opposed to leaving the house at any other time. Yes, because especially in light of Dr. Burgess's testimony about flight or fight with the snails. And she said the snails fled.
All right, let's save our argument
no, but-
for argument.
Well, you asked what I want. Yes, I'm going to argue that.
Jesus, the kids took the pictures with snail. See, that's the problem, Your Honor, and that would give the jury a false impression that these manslaughter instructions are not available if the defendants could have retreated. And there's no question that they could have left, I guess, any time in their 18 years of life. But the fact is that would be a misrepresentation of the state of the law. If they don't have to flee before they could kill totally justifiably, they don't have to flee before they can avail themselves of Flanell.
All right, I'm going to have to think about that and
Please.
look at flannel again. I'm not convinced that you're right. I want to look at that because I'm concerned about the balance of these instructions and how you really deal with it. I don't know if it's balanced that way. 5.51. Strike at 5.50 then is being requested by both defendants.
Yes.
Okay, I'll look at flannel again.
And Your Honor, the people then would request the other instructions as well if the court's going to instruct on a modified version of 5.50.
Okay. Why don't you do this? If you have a modification in mind, you can fax that to me first thing in the morning, or
I'll probably be
counsel for the co-defendant can bring it in and I can review it. And I'll look again at flannel tonight. And if you have any further argument, you can perhaps relay it through co-counsel.
The only other thing I wanted to point out to the court is 5.17, which is the flannel instruction, does refer to the reasonable person standard.
Yeah, that's true.
So it's not totally divorced from the reasonable person standard.
Well, actually, it refers to the reasonable, as this is not what a reasonable person would do. So it's not, it uses the words, but it doesn't talk about the standard in regards to other issues.
All right, well, I'll review flannel, and if you have any particular case that has evaluated this subject, I'll be glad to look at it as well.
So one proposal
Yeah.
that perhaps would cover the problem would be to just in 5.17 add where it says this would be, so even though a reasonable person in the same situation, seen and knowing the same facts, would not have had the same belief or would have retreated.
Or would have taken other action, or would have not taken.
How do people react to that?
Well, I'd like to think about it.
All right, why don't you submit that if you like, Mr. Burt,
Fine.
so we can sort of look at it in its written form. All right, then that completes the self-defense additional instructions that might be requested to supplement the flannel instructions. So we did talk about conspiracy last time, and the defense had submitted 6.10 and cited the court to People versus Horn. And the people had objected to the defense position that there can be conspiracy to commit second-degree murder or manslaughter.
Well, Your Honor, I think the cases cited by the defense stand for the proposition. It seems to me that it's logically inconsistent for it to be a second-degree murder and a conspiracy.
Well, but Horn says otherwise.
Well,
It depends on how you your focus or what your focus is. People versus Horn. If you look at the dissent by Justice Mosk, it makes a lot of sense. And you focus on the thought process of the individuals who are involved in the conspiracy at the time they're conspiring, as to whether something is heat of passion or whatever else. You can clearly conspire in a way that would result in a manslaughter, depending on the circumstances. That seems to be, although the majority came out with a different analysis, came up with the same conclusion.
no, I think because of the cases, the court has to give it.
The defense was requesting you modified 6.10. Is that right?
Yes. The modification was to add murder or manslaughter, and also to indicate that to be an overt act, the act must precede the commission of the crime. The people indicated they had no objection to that portion of the instruction. In addition, Your Honor, we're offering to the court as special instruction number 19, which is in the packet that is submitted as first set of additional proposed jury instructions.
You can leave it in there.
A clarifying instruction which explains to the jury this rather difficult concept of how one could have a conspiracy to kill someone and not be guilty of first-degree murder. And as I think the court is implying, it's not, and as the prosecution indicates, it's not an altogether clear concept, and it's certainly not clear to the jury how one could come together and form an agreement to kill someone and not, by definition, be guilty of a premeditated killing. And yet Horn indicates in the language which we've incorporated into special instruction number 19 how that in fact can take place.
Yeah, I'm looking for your special instructions. Did the people wish to be heard on that special instruction? Or do you have it?
No, I haven't, Your Honor.
Okay.
I'm trying to think. Well, it seems to me that if the court's going to give 6.10 as modified by the defense, that this instruction, I have no objection to this instruction then.
Let me find it, so I'm sure. That's the language of Horn, so that's appropriate instruction.
Now, when these instructions are given to the jury, the authority is not going to be listed on the
No,
instruction.
no, someone's going to have to redo these.
Mhm.
One moment. Instructions here.
All right, I believe 612 and 13, 612 is offered by the prosecution and objected to by the defense. I think that's a correct statement of the law.
Yeah. Did you want to articulate your objection?
Our objection is that this instruction should not be given because it lessens the burden of proof that the people have to show that a conspiracy in fact exists.
Okay, that objection is overruled. It'll be given. People are requesting 6.13.
I believe the defense is as well.
Yeah, okay, 6.13 will be given.
The next two were withdrawn.
Right. 6.17, 18, 19, I'm sorry, 6.21. Start over. 6.17.18, 21, 23, 24 will be given. The defense is requesting 25 and 26. Well, those are, well, it's 26 is just the verdict form, and 25 is the objects of a conspiracy. That has to be given.
Right. Yeah, we were holding them back because of the manslaughter.
Oh, okay. Okay, so you now know what those will be. They'll be given 8.00. And we've already gone through 8.10.
No, I believe there was something about the last sentence of 8.10. They have it listed as a killing.
Okay, well, that won't be given, that last sentence.
So their version,
Well, it'll be just the standard 8.10, deleting all the portions that don't apply.
okay.
Do you know what that'll be? I'm sure we're all familiar with that instruction.
Okay,
So the court would not, the last sentence, the killing is unlawful if it was not justifiable, that would be deleted.
Yeah.
All right.
Then 8.11 is express malice only.
That was discussed earlier.
Mhm.
8.20 is going to be given in its unmodified form, or at least the form, not the defense modification. Eight 8.30, both sides are requesting. Eight 8.31 was withdrawn. 8.37,
I think this raises the issue of whether the court's going to give involuntary manslaughter instructions. And having reviewed the cases, it kind of looks like the court needs to.
what sort of theory of involuntary manslaughter is there?
There isn't one.
Why did you say?
Well, because I was reading some of the cases cited by the defense, and it seemed to indicate that if you give voluntary, that involuntary should be given almost automatically. But there is no theory of
No,
it.
if there's an intent to kill, why do you have involuntary manslaughter? Involuntary manslaughter is defined a certain way. It has
Well,
certain elements to it. What is there of a theory of involuntary manslaughter in this case?
Lack of intent to kill.
Where is there evidence of a lack of intent to kill?
Defendants testified that during the time of the actual shooting, they were not thinking, they were not reasoning, they were not intending to do anything, they were simply reacting.
Now, there's circumstantial evidence because of the use of a weapon of intent to kill, but that's a matter of argument for the jury to decide.
Well, there has to be more than just a lack of intent to kill. There has to be other,
Well, if you hook up Flanell on the one hand and a lack of specific intent to kill, I think you have an involuntary manslaughter. And there are cases that say Flanell applies to
yeah,
involuntary.
it would if there is no intent to kill.
And they're indicating in their testimony that they never testified there was an intent to kill.
Well, I think Lyle Menendez did. He went in to kill the mother. Well, what would he go in there for? And when he did that, Eric Menendez gave him the bullet to do it,
I'm not sure.
or the cartridge to do it. Isn't that
Eric's
what?
testimony was. Moreover, it's not clear what the status of the mother was, either when they left the room or returned.
Well, their testimony was that she was moving.
And I believe the testimony of the coroner was that all of the wounds were preceded death.
It seems to me that the evidence is that there was evidence of intent to kill.
Well, I don't think that that's clear with respect to my client. Ray.
What is the position of Lyle Menendez?
We'd submit the issue, Your Honor.
Are you arguing that there is sufficient evidence for involuntary, or?
On the limbic system testimony, one interpretation of the evidence would be that they were, despite their own statements to the contrary, on automatic pilot, so to speak, and were acting without thought. And we'd be relying primarily on the testimony of Dr. Burgess in that regard, realizing what the court said about the defendant's own testimony.
Well, that's my recollection. Maybe I'm wrong misstating it. It's been a while since that testimony was presented, but that's my recollection. That's why they went back in.
Slice up the activities when it's all happening in this state of panic and non-thought and reactive state is to suddenly say, stop action, and here we have time for rumination and thought and formation of intent, I think is very problematic. And given the testimony about my client's fear reaction and his heightened fear state, given the testimony about the fragmented nature of his memories of these actual episodes, I think there is room to argue that he did not have possessed, given the fact that the missed shots are apparently those behind the mother and he was closer to the mother. I think there's room for, and that there's no evidence really from the physical evidence that he ever shot the father. I think there is room for us to argue, if there's an instruction to support it, that he lacked intent to kill.
Well, involuntary manslaughter has other elements. In addition to an unlawful killing of a human being, there has to be some unlawful act.
Well, there's shooting under circumstances not justifying self-defense. That's an unlawful act.
And the case that the people feel supports this position is Burroughs.
No, I can't remember the case that I read, Your Honor. It was one of the cases cited by the defense, and I can't remember which one it was.
Which case was that, Mr. Burke?
There is Burroughs, cited 35-820.
Well, Burroughs has to do with the whether it's involuntary manslaughter if the killing occurs during the commission of a felony which is not inherently dangerous to human life. And that was the theory upon which we proposed the involuntary manslaughter instruction, that they were in the process of committing the offense of assault with a deadly weapon. That's a non-inherently dangerous felony in the abstract.
Your Honor, it's very
Well, then
clear.
you get into implied malice also. When you go back to the discussion of implied versus express malice.
Your Honor, it was very clear from the defendant's testimony. They didn't go in there to brandish weapons or to scare their parents. They went in there to shoot them. And, I mean, that's what they testified to. And so it's not as if they went in there just, and they did it because they had this belief that it was kill or be killed. So it seems to me that they did have an intent to kill.
it's hard to argue from the facts of this case that there was not an intent to kill. It's just, at least from the evidence I recall,
I think intent to kill is a subjective state of mind, Your Honor, not just walking into a room with a shotgun. I mean, if the intent is to preserve yourself and you're not thinking all the way through to intent to kill, I don't think that there is at least not direct evidence of intent to kill. Now, that people can argue circumstantially. But the jury's made, the jury could find that my client was, given his history and given his psychological makeup, that he was reacting in pure panic as a hyper anxious person and did not think clearly enough to formulate an intent to kill, was merely reacting automatically to panics.
With respect to Eric Menendez, I believe he testified that.
well, we're not really going to resolve his situation. Well, as much as possible, just deal with Lyle Menendez. I just, at this point, don't see it as to Lyle Menendez as an involuntary manslaughter. There is insufficient evidence to justify that instruction. The people had a case that they saw that was cited by the defense that seemed to support that position. Well, I'd certainly like to see it.
Your Honor, I can't find it right now. All I can do is perhaps this could be deferred until tomorrow because.
Puts me in an awkward situation here where the
I know.
defense cites the case, the prosecution agrees it supports the position, and neither side, nobody knows about it.
This is sort of bizarre, isn't it? It's the case that applies.
Well,
Right. At this point, we can do some of this through teleconference tomorrow and/or fax and do on the record put on the record what we've done tomorrow before the argument. But at this point, I'm going to reject 8.45 and the involuntary manslaughter as to Lyle Menendez, with the understanding that both sides can review the matter. And then we go to 8.40.
I believe
Both
that's,
sides have requested it. It'll be given. 8.42 is given in its standard form. 8.43 in its standard form. 8.44, both sides request.
yes.
8.45 is what we have been discussing regarding involuntary manslaughter. And if you have a proposal on involuntary manslaughter that deals with the theory of why it should be given as far as filling in the blanks on 8.45, I'd like to see it from the defense. I know you submitted one, but it doesn't, I'm not sure if it relates to the flannel discussion we've had.
I think the case that the people were citing to the court is the case in the comments, People versus Welch, which says where a jury could find from the evidence that the nature of the attack by the decedent did not justify the resort to deadly force in self-defense, or that the force used in self-defense exceeded that which was reasonably necessary to repel the attack, the defendant is entitled to an instruction of involuntary manslaughter as a lesser included offense to a charge of murder.
That's not the one I have in mind. There's a specific case that says Cornell applies to
Okay.
involuntary as well.
Well, that might be in the manslaughter instruction dealing with flannel.
Try and find it. Which one is it, Marcia? 8, 5.17. Let's see, it's got contemplated.
All right, let's move on to the balance of the instructions. 8.50, 70, 71, 72, 73 will all be given in their standard form. 8.70 was, strike that, 8.74 was submitted by the defense.
Could we return to 8.73 for a moment?
Yeah.
This instruction is limited to a situation where the jury finds that the provocation was not sufficient to reduce the charge to manslaughter, but indicates that they can take the provocation into account in deciding whether there is first or second degree on a theory of premeditation or deliberation.
Right.
And on its face, this instruction does not apply to the special circumstance of lying in wait, which, as it's written by Calgic, does deal with a state of mind equivalent to premeditation or deliberation. That's the way it's phrased on the lying in wait instruction. And it also doesn't indicate what, if anything, the jury should do if it decides that the unreasonable self-defense doctrine is not sufficient to reduce the crime from murder to manslaughter. In other words, can you take the Flanell situation into account in deciding on the issue of premeditation or deliberation for the theory of first degree murder and also for the lying in wait special. So I drafted a proposed instruction number 22, which would read, if the evidence establishes that there was provocation or any belief in the necessity to defend against imminent peril to life or great bodily injury, which played a part in inducing an unlawful killing of a human being, but the provocation or belief was not sufficient to reduce the homicide to manslaughter, you should consider the provocation or belief for such bearing as it may have on whether the defendant killed while lying in wait or with or without premeditation and deliberation. And we would request that that instruction be given as a proper expansion of the principle of 8.73. And we cite to the court in support of that instruction, People versus CEJA, C-E-J-A, which is at 4 Cal 4, 1134. And that case deals with the sufficiency of the evidence for a lying in wait special circumstance, or rather lying in wait as a theory of first degree murder. And the court throughout the discussion assumes that heat of passion could reduce the mental state that's required for lying in wait. So I think it is a proper modification to say that the jury, and in fact, as I say, the instruction on lying in wait does talk in terms of a state of mind equivalent to premeditation or deliberation.
What was that citation again?
CEGA, and the site is 4 Cal 4th, 1134.
All right, if you want to, I noticed that you were reading off handwritten notes there. If you wanted to prepare that
And I'll-
instruction and then
yes.
fax it to me tomorrow morning, I'll look at the case.
All right.
And I'm assuming, perhaps incorrectly, that the Eric Menendez defense would want that as well.
Yes, yeah.
All right, so when I get it tomorrow, we'll have further discussion on it. I'll look at the case. All right, 8.74. Other than perhaps a modification dealing with involuntary manslaughter, that's just a standard instruction. And we all know what it'll be once we get the final resolution of involuntary manslaughter. 8.75 was rejected at this point, waiting to see if it's going to be needed by the jury.
Right, it's a question for
8.80, we were holding off to discuss it with the co-defense counsel, the third paragraph.
Okay, this
This was the one where we had, it's always a confusing instruction dealing with the actual killer or co-conspirator or aider and abettor and all that. And I don't know if you folks have sat down and just thought it through as to how you would modify it to deal with the facts of this case. If not, I think you should, because it just requires somebody to just sit down and go through it. Otherwise, I'll just do it. If you want, I'll just do it and give it to you in its final version.
We did propose a modified version to the court of 8.80.
And the people had objection to it. As I recall, maybe not. Like there was just,
No, we wanted the standard one.
and we were holding off for co-counsel to review it. I don't know if you submitted the same one or a different one.
I think factually speaking, for our client, there should not be any reference to the actual killer. I think with respect to our client, they do have to find an intent to kill.
First of all, with respect to the last sentence, when the people say they want the normal instruction says, if you find beyond a reasonable doubt the defendant was the actual killer, you need not find that the defendant intended to kill. That's incorrect with respect to the line and weight special. That does require intent to kill, so that's wrong on its face.
What are you reading?
You're reading from the third paragraph?
Yes, third paragraph, last sentence in the brackets.
You still need.
Right.
Yeah, well, for the multiple number.
And there's some feeling by the Eric Menendez team that there's a distinction between the two.
Yes. Our client's not, based on the coroner's testimony, our
And
client's not the actual killer.
as to the multiple murder special, the people's only theory here is express malice. And in order for the people to get a second and a first, there is necessarily a finding of intent to kill. So I don't think it's correct on either special circumstance to indicate to the jury that there is no requirement of intent to kill.
All right, people want to respond to that?
No, I need to sit down and read this again and think it through, because I think there is a difference in position between the two defendants.
All right, but as to the Lyle Menendez jury,
The proposal of the defense is their particular modification, correct?
all right, instead of taking time now, I'm going to direct that if you have some other modification or a modification of paragraph 3, you submit it to me tomorrow morning. This is the defense version, so if you have some other version, I'll deal with it that way. Otherwise, we'll just sit here while I'm reading.
The other suggestion would be to simply eliminate that third paragraph. Since,
It's always the easiest way to deal with it.
as I just indicated to the court, intent to kill is going to be spelled out in the instruction on line and weight as a requirement. And the multiple murder intent to kill would be implicit in the court's instructions on first and second degree. So the court could eliminate that whole third paragraph and simplify the whole matter by giving the rest of the instruction.
That's what I proposed. That's what I submitted.
Okay. All right, is that your request as well?
Yes.
Okay, then let's do it that way.
Well, we're not joining in that at this point.
Okay.
Right.
All right, and going through 8.81.3 will be given, 8.81.3 will be given, 8.81.15, the people's version is given, the defense version has been refused. 8.83 is given, 8.83.1, 8.83.2. And that brings us to 17.01.
I think they withdrew their version.
Not according to my notes.
Oh.
It could be, but I just haven't written it down. What is the defense position?
Your Honor, the problem with the defense version is that overt was excluded. And so the version that we submitted had the word overt in front of the acts. I think that was the difficulty.
I have no problem with adding that word. That's the only problem.
Otherwise, I think this is. Right. The one offered by the prosecution is the same as the defense, except for overt has been added to the prosecution's version.
Then we have no objection to it.
I don't recall that the split in authority has been resolved on overt acts.
That's correct, I think.
I don't see any need to give it. The jury isn't making any findings. Strike that. The overt acts are not substantive crimes. They're just part of the conspiracy. I don't see any need to put in the overt. People want it, and the defense doesn't object. Is that it? To the overt?
Mm-hmm.
I'm at a disadvantage because I don't have 1701 in front of me.
That's
but I-
the jury must be unanimous in regards to
Which overt
the acts committed by the defendants.
Yeah, Your Honor, we proposed it in an abundance of caution. Here. See.
And the use notes cite cases that go both ways as to whether it's required to be given in a case where conspiracy is charged, since overt acts are not really crimes themselves, but just part of the crime of conspiracy or theory of conspiracy.
It seems that it still would apply, and this is why act is better than overt act. It would still apply to the agreement, the underlying agreement. Suppose some 6 jurors thought that they made an agreement prior to the Perry Berman incident, and 6 other jurors felt that no, the agreement was formulated on the steps just prior to the parents going inside the door. I think the unanimity has to be as to the agreement at the very least, if it doesn't extend to the overt acts.
I don't agree with that.
Your Honor, there's no requirement as to when the agreement take place legally.
No, but that's the point, is that the people are taking a shotgun approach in terms of, well, the conspiracy could have been formed at various points along the way here. And since agreement is an element of conspiracy, then the people are required, or there is a unanimity requirement with respect to which agreement is being relied upon.
It seems to me this is just one crime being prosecuted possibly under more than one theory. I don't see that this is an appropriate instruction at all. Both sides have submitted it. And the prosecution is asking for more than the defense, and asking that more be included as far as greater burden on the prosecution to show overt acts.
I think my instruction, or the defense's instruction, would extend both to the overt acts and to the agreement itself.
And it's people's position that the defense instruction should not be that broad, because that's not the law. They don't have to agree what act or acts constituted the agreement that formed the basis of conspiracy. They don't have to do that.
Well, the way, this instruction could be interpreted by the jury as requiring that all 12 jurors agree that a particular shot was fired by the defendant, one defendant, that all 12 jurors must agree that he fired a particular shot. That's not the law.
Your
All
Honor,
they have to do
that's,
is agree that he,
no, Your Honor, that's not the people's theory. I mean, the people are giving it just to say that the 3 overt acts that are alleged in the conspiracy, and that's
I
all it
understand
should
that.
apply to.
I don't think it should be given at all. It's just
Right.
create confusion.
Well, that's fine.
So this can be refused. 1702 is given. 1710.
That will depend on what the court rules.
Yeah.
It's the people's position that there is no such crime as conspiracy to commit involuntary manslaughter.
Well, there's certainly no crime of attempted involuntary manslaughter.
That's true.
So it would be hard to conceive of a conspiracy to commit involuntary manslaughter. But you can think about that.
If there's a conspiracy to be negligent,
Doesn't seem likely that.
People object to 1711 as being the same statement of 8.71.
Court
We
already
discussed
indicated.
that.
Oh,
That's
okay.
not going to be given.
So,
And 17.30. $17.31, it's not going to be given.
17.31 will not be given.
Oh, I'm sorry, 17.31 will be given. Sorry. Oh, no, it's not going to be given. I'm looking,
All instructions not necessarily
hold on,
applicable.
I'm looking at 17.32. Okay, 17.40 is given, 17.41, 45, 47, 48. Objection on 49, or just,
that was in abeyance.
it'll just say there are several verdict forms or whatever. I'm not going to enumerate them. I routinely will, at the end of instructions, go through all the verdict forms with the jurors so they understand what they are and how they're to deal with it, as to one verdict form per count, so that we don't have more than one verdict, or one, they only are to fill out one verdict per count. Unless later on there is an indication of a hung jury or something where we give an instruction telling them to come in with partial verdicts.
Assuming the court did not give involuntary manslaughter, am I correct that as to the homicide charges, the court would give guilty, not guilty as to first, guilty, not guilty as to second, guilty, not guilty as to
Not guilty,
involuntary?
just not guilty, and then guilty of first, second, or voluntary. I don't give
there's only
separate.
one not guilty verdict.
I don't give separate not guilties. It just creates more confusion. If we have a potential of a hung jury, then I would submit the not guilties and tell them how to deal with that if there's a possibility that they reached a verdict on a greater offense. But to give them not guilties on each, it just creates confusion. Unless everybody thinks otherwise, but that's normally my routine, not to give.
I just can't have them on all.
You can get guilty of more than one count, of more than one charge, or guilty and not guilties and conflicting verdicts and all sorts of things that create confusion, and there's no real reason for it when the way they're instructed, just come back with one verdict as to any particular count. So anyway, that's how I'll do it, unless everyone strenuously thinks otherwise.
I strenuously think otherwise. I want guilty and not guilty for each of the counts.
Well, for each count, yes, but the judge is talking about for each lesser.
No, I'm talking about that also. Guilty, not guilty for first, guilty, not guilty for second, guilty, not guilty for manslaughter.
Okay, and what is the people's position?
People's position that it should be one not guilty verdict, and the three verdicts for
Well,
the.
historically, that's been the custom here in Los Angeles. That's the way we do it.
And unless and until the jurors need help and the special instruction has to be
Oh, it's
given.
fine, yeah.
And I think I think at that point then, the court might give them.
That's what I would intend to do. You know,
Is he gonna give that?
then 17.50, 5.2.
They withdrew.
All right, how about the specials then? You want to take a short break and then we'll do the specials?
Yes.
Okay, let's make it no more than a quarter after so that we can get going. So this will be about 6-7 minutes.
No, I cited the court to the cases which I think support this instruction, and I have nothing
All right.
in addition to add. Basically, and it's also argued in our moving papers as to why these instructions should be given.
All right, the court finds it's argumentative and is inappropriate in the way it's presented, focusing on certain aspects of evidence presented by the defense. And the court specifically refers to People versus Wright at 45 Cal 3rd 1126 regarding argumentative instructions.
What was he saying he's not giving?
Special instruction 2.
You didn't answer the same thing.
Yeah.
All right, again, it's argumentative in its format under the Supreme Court's holding in People versus Wright. Again, it's inappropriate as phrased. As we get through these, I believe there is one that is more appropriate, but clearly if the focus is on prior threats and prior acts, there is appropriate purpose for such an instruction. It's just the wording and the length of the instructions that concern the court and the argumentative nature of it.
For the record, Judge, in special instruction number 2, the line 21 has, as a reasonable person, we would submit the instruction to the court without that language in it in light of the court's ruling on perfect self-defense, and argue that this instruction would nevertheless be applicable to the imperfect self-defense doctrine.
So you just want to do substance acted in good faith, or acted with a good faith belief
Right.
in protecting his or his brother's life or bodily safety.
Right, but the content of it is is argumentative in the way the overall instruction is phrased. As I said, there is a valid position of the defense to have an instruction that relates to prior threats and prior acts, but this is not the appropriate vehicle for that. And number 3.
Number 3 is phrased exactly as it was phrased in the cases cited where the court held that it was a reversible error not to give the instruction. And in those cases, the theory was perfect self-defense. So the only modification which would be required would be, in light of the court's ruling, the last sentence reads, in determining whether the defendant acted reasonably in protecting his own life or good faith or bodily safety, we would propose to substitute.
We have reasonable cause.
Just take out the
Correct.
word reasonable.
Take out the word reasonable and whether the
Add
defendant
an actual
acted
Just call it good cause.
honestly in protecting his own life or bodily safety, since the Flannel instruction refers to honest belief.
People wish to be heard on that.
Wait, are we talking about and reasonable cause to fear greater peril?
Well, that would
Good
not,
cause.
it would have to be a good faith belief or something along those lines.
Well, I object to the use of the word honest because
I really don't understand why they put that in the instruction and then there's other ways of doing it. Actual belief or a real belief or something else. It's really
Sincere belief.
something, but
Just put honest.
we're stuck with the phrase in the flannel instruction unless everyone wants to modify it as well. I don't have any problem with modifying because I don't, honest belief, it does really have some ambiguity to it as to what it means.
How about actual belief?
That's the way it's really intended to mean actual belief.
I like that.
All right, why don't you, if you want to word this a little differently, Mr. Burt, you can present it, and this is the type of instruction that I had in mind as far as the threats and things of that nature.
Well, but you have to get into the abuse too, which is different from that.
Well, how about in line with 5.17, the last sentence would be modified to read, where it now says whether the defendant acted reasonably in protecting his own life or bodily safety. I would substitute the word whether the defendant acted in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, since that then would track 5.17.
Sounds fine, but oftentimes you have to see it in its final version as it's written out. If you want to do that and bring it in tomorrow or fax it or have it brought in tomorrow so that we can look at it.
And then we'd also strike out the word reasonable in the second paragraph, third line down, line 15.
Yeah.
Just had cause to fear.
All right, if it's modified, we'll look at it tomorrow and as I said, an instruction along those lines will be given as far as the specific language. We'll have to see it as it's prepared. All right, instruction number 4.
and we object to that as being another statement of 5.17, as well as special instruction 5.
Because you have no objection to number 5, but you have objection number 4.
No, we have the objection to both of them is that it's just another statement of 5.17.
5.17, you are dealing with an honest but unreasonable mistake as to the necessity to defend. And special instruction 4 and 5 have to do with an honest but unreasonable belief in the amount of force necessary. And it would seem to fall within the same principle of flannel.
Well, it's number 4 starts out with a person who has the right of self-defense, which we don't have here. Isn't that right?
Well, it starts with the person who otherwise has a right of self-defense, and then explains that that person who then goes above and beyond the amount of force that's necessary.
Well, the force was not necessary here, period. So you've gone beyond.
5 is offered as an alternative to that criticism.
5 is, how does 5 differ from the final instruction?
It adds the concept about honest belief in the amount of force necessary. It exactly tracks Flannel as to the honest but unreasonable belief in the necessity to defend, but adds to it the concept that if the honest but mistaken belief is as to the amount of force used, that Flannel would still apply.
Other than the repetition of language in 5.17, what is the people's objection to number 5?
That is not the law. It's an expansion on the law offered by the defense in this case.
All right, you disagree then with the concept set forth in the second full sentence of the instruction.
Like the one that says likewise a person.
That's true.
All right, this to some extent relates back to our discussion of the law of retreat, dealing with Flannel.
Your Honor, you know what I think it may be the problem here? I think there's a very simple notion here that may get lost in all the necessary verbiage of a jury instruction.
That's one of the big concerns that we all should have, is that these instructions are cumbersome, and the more we try to put into them, the more confusing they become.
In any event, the thought that I had, and what I think is the governing principle of Flannel, is that if you act out of genuine fear, okay, you're not harboring malice. And I think that's the notion that has to be kept in the forefront. And it applies to these subcategories of self-defense just as much as it does to the basic notion of the right to defend. In other words, if you're using too much force, but you're motivated out of a good faith belief and motivated by fear, then you're entitled to the benefit of that state of mind so that malice doesn't suddenly click back in. I think that's the guiding principle. So any effort by the prosecution to somehow cut back on that principle, that good faith fear somehow can wind up being murder again, is what has to be resisted and clarified. And so, we'll try to figure out a simple way to do that. But I think rather than get hooked up in the verbiage of all of the various permutations of the self-defense instruction, is to simply keep in mind that if the law does not require you to act reasonably, if all it requires is a good faith belief, that good faith belief can cover any and all permutations of the self-defense scenario.
Can it, though, if the reaction is to a simple assault and the response by the defendant is
An atomic
so out of proportion that it is just outrageously out of proportion to the provocation or the action of the victim?
That's when the jury has to ask, can I say that this is an honest belief? Is this person acting in good faith? That's where all this good faith and honest language comes, because it does have that judgment attached to it.
Well, then that perhaps relates back to what you were saying, is how you relate that to the jury, or how you tell the jury that. I understand what you're saying, and there's logic to it as far as that's what I was saying earlier, the good faith aspect is the focus of the finding of the jury. If the jury makes that finding, the problem is to deal with it in the context of other activities that go beyond just the state of mind of the defendant, but what actually occurred and what he was permitted to do. So if you have some proposal, I'd be glad to look at it. The defense for Menendez has submitted about 15 proposals to deal with that, and that's what we're going through.
I know.
And I'm not convinced that the number 5 is accurate as stated either, Mr. Burt.
So 4 and 5 would be refused.
At this point, again, if you can come up with something that deals with the subject that we're discussing, I'd be glad to reconsider it. But it's going to have to be early on Wednesday morning so that we get started. Unless you want to do it tomorrow, come in tomorrow and do it.
We don't want to
No.
come in tomorrow. So.
Well, you will.
Well, I don't know. We have a proposal
Well,
to
okay.
to ultimately save time because this is becoming extremely confusing.
Well, that's.
And what we'd like to do is cut out all the instructions that there's no point in discussing anymore and just come in with the ones that are.
That's fine, but I want to do it tomorrow so that we can just get it done. I don't want it to interfere with whatever might be needed to finish off the argument on the co-defendant's case. I agree there's going to be additional confusion because there are instructions that relate only to Eric Menendez, but we have to get it completed so that we won't have any interruptions with the argument.
Your Honor, should we assume or should we not assume that we're going to be arguing Monday the 13th?
As of now, unless, you could prepare for Friday just in case everyone talks very fast and finishes their argument Thursday afternoon and I instruct. Why should we have Friday with nothing to do if we have the jury notified to be here on Friday? What I would ask is that counsel all show each other any charts, diagrams, or any demonstrative items that you're going to be using in your argument prior to the time argument is to commence, so we don't have big disputes about what each side is going to use. I know it's hard to imagine that we would in this case, but it's possible. Number 6.
One of my favorite supplements is Counsel turmeric. Turmeric helps with healthy joints and inflammation support, and Counsel has the #1 doctor recommended form of turmeric. Counsel, the brand I trust.
This was submitted in anticipation of the court giving a self-defense instruction.
Number 6 will be refused. Number 7, in my view, doesn't state the law of California on imminent danger. And it'll be refused.
They're not listers. He's not going to use the same ones.
No, he's not using the same.
Number 8.
Number 8 would be modified to refer to imperfect self-defense.
Your Honor, I'm sorry, was number 7 refused?
Yeah.
Thank you.
I don't know how you'd modify that as to what you would propose to do.
Well, that's the reasonable doubt if it's murder or manslaughter. If there's a reasonable doubt.
Well, that's already an instruction.
So that would be refused.
Yeah, it certainly doesn't relate to what's occurring now. And number 9, there's not going to be an aiding and abetting, as I understand
That's withdrawn.
it, so it won't be given. Number 10.
10 and 11 are submitted on the theory that Calgic does instruct the jury in 2.40 and 2.42 on the use of character evidence when the defendant puts on evidence of his good character. But it does not deal with 1103 evidence, and there was extensive 1103 evidence in this case, and 10 and 11 are modeled on 2.40 and 2.42 in terms of the language.
Well, Your Honor, instruction 11, for instance, is a statement of admissibility of evidence, and I don't think that the jury needs to know what's admissible and what's not.
True. As far as 10 and 11, what is the people's position?
Well, Your Honor, it's people's position that they should be refused, especially 11, which is just a statement of the admissibility of evidence. We could have an instruction for all kinds of principles of admissibility.
All right, assuming that was deleted and the focus is on the character of the victims as to what, if any, use the jury should make of it.
I think they're argumentative, Your Honor. Especially in 10, at line 16, it may be reason that a person of bad character for violent or abusive behavior, for violent or abusive behavior, et cetera, et cetera. I think that if this kind of instruction is going to be given, it should be more neutral in terms of its language.
What's wrong with 10?
That's what I was just reading from.
Ten is almost verbatim modeled after 2.40. And 2.40 says good character for the traits involved in the commission of the crime charge may be sufficient by itself to raise a reasonable doubt as to the guilt of a defendant. It may be reasoned that a person of good character as to such traits would not be likely to commit the crime of which the defendant is charged. Special instruction number 10 is no more argumentative than that instruction, and it deals with the same principle, which is how does the jury use evidence of character?
Well, 10 would have to be modified to delete self-defense or change it in some fashion.
He's still in defense of just,
In the heat of passion.
no. You're using heat of passion. You want it to be both.
Would
I
be
don't know if it needs
perfect.
it. I don't even know if you need that paragraph at all. Just say, start with the second paragraph.
Well, and I would object to the term bad character and just,
Just character.
yes.
The evidence has been received in this case which may tend to show the character of the alleged victims for violent or otherwise abusive behavior.
So the court would delete the first paragraph and give the remainder with the word bad stricken.
Yeah.
Well, Your Honor, I would object to the language starting with such evidence may be sufficient by itself to raise an inference that the alleged victim acted violently or abusively toward the defendant at the time and well before the homicide.
At the times testified to in the trial, I think both, which would encompass both, and that solves the problem.
I think that.
It is argumentative when you get to that point.
Mhm.
Just evidence has been received in this case which may tend to show the character of the alleged victims for violent or otherwise abusive behavior. It may be reasoned that a person of such character or violent or abusive behavior would be more likely to act violently or abusively on another occasion. And delete that second sentence. How's that?
So delete the second section, the first paragraph, the second sentence, and the words bad.
Look, why don't you take a look at ours.
Read,
Your Honor, do you have our special instruction number 11?
Yeah, I'm just trying to keep it separated, but I have there.
They might like this. What about this?
Do you have the special instruction?
That's what it covers it. Don't you
I
think?
think it leaves out the objectionable paragraphs.
Sort of shorter and seems to cover it.
That's what we objected to.
How do the people react to that one?
Your Honor, it's basically got the same defect. It's got the such evidence may be sufficient language, which
That's the whole point.
should be, and I also object to the victims being referred to by name in the instruction.
But it's patterned after the Calgic 2.40.
Yeah.
Well, that's a separate, that's an instruction that's only a positive instruction that goes to the good character of the defendant. And you've twisted it around to the bad character of the victims, and somehow you're equating the two.
But
Yeah,
it is,
so you might as well take, or you could take some other defense instructions and twist them around too. That doesn't necessarily work.
Well, I don't think we've framed it as the bad character of the victims, but we've described their character for violent and abusive behavior. And there certainly has been plenty of testimony that they had such a character.
and it's only being suggested that it may raise an inference that they acted in conformity with that character trait, which is what people tend to do. Now, you can't say that with respect to a criminal defendant because you don't want him judged in any given case on bad character, but the same consideration does not follow when you're talking about the decedent.
Your Honor,
Since
I don't-
they're already dead.
I don't think we should have instruction which talks about raising inferences. I think that the modification proposed by the court to allow Menendez's special instruction 10 is the more appropriate statement, which is to delete that sentence starting with such evidence and the terms bad.
Yeah, I don't know of any law that says that such evidence may be sufficient by itself to raise an inference that is argumentative.
Well, the only reason that's in there is, again, going back to 2.40. It's really, the court can say it's being twisted around, but it's 2.40 deals with character evidence. The defendant is submitting it to raise a reasonable doubt. Instruction 10 doesn't go so far as to say it's sufficient to raise a reasonable doubt, which would be the more argumentative, but restricts it to sufficiency to raise the issue of acting violently or abusively.
Well, I think the way it's phrased, it may be without that second sentence. It may be a reason that a person of bad character for violent or abusive behavior would be more likely to act violently or abusively on any other occasion or any other occasion.
Bad character or such character.
Such character.
So as I understand it, the first paragraph is out.
Yeah.
The first sentence of the second paragraph is modified so that the word bad is stricken.
Yeah.
The third sentence is stricken. The fourth sentence is modified,
Victims. Don't call them decedents. Don't call them victims.
is modified so that the word bad is changed to such. And the rest of the instruction would be given.
And again, change bad character to such character.
Bad and good are sort of necessary in that last.
No, I mean, the next to last paragraph.
That's where it's
Yes.
necessary, because you have to contrast it with good.
In other words, you're contrasting.
Oh, okay. No, just say such character for violent or abusive behavior may be refuted or rebutted by
Contrary,
evidence of,
by contrary evidence.
I don't like it, their stupid photographs.
whatever, something like that.
All right. Contrary evidence.
Period.
If there has been any, which there.
However, so it would then read, however, evidence of character for violent or abusive behavior. Correct? Just strike out the word bad.
I thought it was going to be such character.
Doesn't matter either
Okay,
way.
it doesn't.
Evidence of such character.
It's actually a character trait, but all right.
Okay,
Trait of character.
By contrary evidence, period.
Special instruction 11 is recused.
yeah, I'll dealt with it in 10.
Your Honor, special instruction 12 seems to be an amplification of 8.44.
It's a lot, I don't know.
All right, did you wish to be heard on that one?
These next series of instructions are submitted under the authority of Wharton and Tompkins. In both those cases, all the Calgic instructions were given, and the court indicated that these are proper amplifications of the heat of passion principle. And the special instruction number 14 is
I'm still on 12.
an alternative to number 12 in terms of the language.
Yeah, what I was thinking about in 14, and just to simplify it, we get caught up with the language in appellate court opinions, and the language is not always any better thought out than our off-the-cuff remarks here in court. But sometimes it is, if anybody's listening.
I'm sure there will be sooner or later.
But it seems to me that do we really need all of the descriptions here?
Violent, intense, overwrought, and enthusiastic?
What does enthusiastic mean?
I don't know.
Well,
No,
out of the,
strong is as good a word, I should think.
Intense is there.
Tense is good.
well, how about striking out everything after the word any and picking it up with emotion, but maybe any emotion which causes a person to act rationally and without deliberation and reflection. And then the rest of the instruction would be given. Because I agree with the court on the verbiage, and the only reason it's submitted in this form is because
That's
that's
what
the
they said.
instruction which Tompkins and Wharton said had to be given.
Yeah, and they just picked it up from what some argument some lawyer made.
Some
Right.
law clerk in some lawyer's office drafted one.
But I agree with the court that it would be a simpler instruction if we took out the verbiage.
People wish to be heard.
Are we on 14 or
Yeah.
12 or?
14 is going to is being considered in exchange for 12. Just simplifying it by saying the passion necessary to constitute heat of passion need not mean rage or anger, but may be any emotion which causes a person to act rashly and without deliberation and reflection.
Makes sense to me.
That sounds fine.
God, reads like English now.
Which is the
Doesn't know how to do
language,
that.
this is the language in the cases.
That sounds fine.
All right, so 14 will be given,
Okay,
12 will be refused.
Specifically, history of useless.
Yeah, I think 15 is a better statement than 13.
That's what I'm concerned about.
And 14.
Well,
Judge, could we return for a moment to 14?
to make this any
Could we add the word
including fear, you want to put it here.
after the word emotion, the word including fear, which causes a person to act rationally and without deliberation and reflection?
You have to specify the emotion here in this case.
People wish to be heard on that?
Yes, Your Honor, it's to pinpoint. Their
Well,
entire-
that is mentioned in one of the cases. I'm not sure which one now, Burnham or
Logan is the fear case, I think.
Yes,
and I
Logan.
think it's discussed in the instructions or the cases that deals with flannel,
That's what I'm concerned about, me too.
if I'm not mistaken.
Select who.
Let's put it this way, I would give it unless I've find that my recollection isn't correct as to the case, but I think it's correct. That would be an appropriate instruction as you propose to modify.
So it would then read, the passion necessary to constitute heat of passion need not be rage or anger, but may be any emotion, including fear, which causes a person to act rationally and without deliberation and reflection.
I believe that's a correct statement of the law.
Right.
And the second paragraph would remain about verbal provocation.
I can't find it at the moment, but I'm going to review my materials. But that'll be modified. That'll be the modification of 14 to include fear.
It is the Logan case. That's the case that's cited in support of instruction number 12. And that language is taken from Logan, which says such passions as desperation, humiliation, anger, fear, rage, or any other violent, intense, highly erotic emotion.
Okay, again, you're modifying 14.
14.
And where are you going to insert it?
After the word emotion, we would insert the words including fear.
All right. Right, that'll be modified. And I'll look at Logan then to verify. Okay, 13.
Your Honor, we would propose that the last paragraph of 13 be substituted for the last sentence of 15, and then 15 be given in that form.